Good morning, good morning, good morning. It is Friday, January 24th. We are back in court in Idaho today for the ongoing hearings from yesterday, Thursday, January 23rd. As a brief, what is happening here? The defense made all of their motions for suppression of a wide variety of things, but it's basically all. So they made all their motions to suppress the search warrants, the IgG or investigative genetic genealogy, data, DNA for those searches. Some of that was sealed. Some of that we heard. We only got the arguments. We did not hear the witness testimony that was sealed. The IgG DNA will not be evidence in the trial. It is an investigative step before they get to other investigative techniques like pulling trash off of a curb and taking what's in it and then testing that for DNA. That was the next investigative step. But the defense is going after every link in the chain, as is their job, particularly when we are dealing with a capital murder case. They are going to argue every link. And if you get rid of the top link in the chain, everything below it falls. I think that's the best analogy I can give to very simplify fruit of the poisonous tree and Fourth Amendment criminal procedure. So the argument from the defense broadly is that there were investigative problems and therefore everything should be suppressed. I don't think the court, specifically with the IgG DNA, is persuaded at this point, but we will see. Judge H is sassy and is incredibly smart. I don't know if I have seen a judge with this level of grasp on such complicated facts in a while. There's a lot of information in this case. There are a lot of complex facts in this case. The defense yesterday said there were over 1,000 pages in the defense filings and submissions. And when the defense made an argument yesterday at one point, the judge said, can you point me in your filings? And there's maybe 15 filings. Can you point me in your filings to where that is? And he didn't ask that question because he didn't know. He asked that question because he specifically knew that it wasn't there. And defense counsel was like, well, Your Honor, we're bringing it by argument. So it's not in the filings. That level of grasp of what's going on in this case is incredibly impressive. He is incredibly smart and has a great memory. He also questions like an appellate judge, more so his style. Or a law professor, which I wonder if he's ever taught law school. He reminds me of a lot of law professors where he is not going to just let you repeat your arguments that you made in your filings. He's going to ask you specific questions on the things that he needs to consider. And I appreciate that. And occasionally the dry humor comes out and I'm like, oh, Your Honor, there's a little bit of humor there. I appreciate it. And what you will see from judges like this is that both sides get questioned, sometimes on the same point, sometimes on different points, but both sides will catch it from this judge. Okay, well, what about this? Okay, well, what about that? Which is balancing the information. You should balance both sides. Both sides should be asked challenging questions. And I appreciate it. I like this judge quite a lot. So you will hear me continue to tell you how much I appreciate Judge H. So with that, today we're going to get back into more motions to suppress. We're going to hear more about discovery, what the defense has and doesn't have, where some of those challenges have been for the defense. And it seems like, frankly, some of those challenges for the prosecution as well, because once the FBI was done, they're like, oh, you want discovery from us? You're adorable. Sure. Let us get that to you eventually or never, which is frustrating for all the parties involved. And we will see witness testimony. We are going to hear more about the search warrant affidavits. We may or may not hear more about the Franks hearing, which is what the defense was asking for at the end of the day yesterday. That's like a hearing to decide if you get a hearing. So the motions were filed. There is a threshold that must be met by the defense. If that threshold is met, then there can be a hearing. I don't know if the defense has met that threshold yet. If the defense has not met that threshold, then there's not a hearing. But they have moved on to all of the other stuff in this hearing. The judge has taken things under submission, and this judge turns around his writings pretty quickly. What is interesting is that because so much is sealed in this case, has not been made public in this case, which in a high-profile case, I can understand where the hesitancy is, especially when it comes to things like the IGG that won't be evidence. If a jury pool hears too much of that, could it be a problem? Because the jury's not going to hear it eventually anyway. This is information that will not be known to a jury when this goes to trial, and the court knows that. So I understand the protection, and the court has indicated multiple times that it will be unsealed down the road. Do I hate waiting? Yes. Do I understand the judge's caution? Yes. Does my own desire to know and our desire to see everything in this case override that concern in this particular circumstance? I don't think so. And I think the concern for finding a fair and impartial jury and only doing this trial once overrides some of those concerns. Doing this trial more than once would be miserable for everyone involved. And when you are dealing with a capital case, the length of appeals will be decades. And so this is a very much every single I is dotted, T is crossed, period, end of sentence. This is going to be done methodically. And I think this is the judge to do it methodically. I mean, we've seen it. We've seen him be absolutely methodical, which I appreciate. So we will learn more things today. We learned new things yesterday, things that we had not heard before, just because a lot of these conversations have not been publicly available. What does that mean? It means I am keeping an open mind in this case. As always, Bryan Kohberger is innocent till proven guilty. We have a very minimal amount of information in the public eye, and more information will be coming, but we're really not going to know till we get to trial, which is hard. It is hard to know that we know these things are true, but we also know there are these other questions, and where are the answers at the end of the day? It's going to be with a jury. So there are going to be questions, but court's a long process. It is very much a long game, which is challenging. But the more we watch trials together on this channel, and just from my own experience as an attorney, things change in trial. Things change in trial. Things will catch you in trial where you're like, oh, I did not see that coming. I did not see that coming. And in almost every trial we've seen, there has been a moment where I've sat here and looked at you and said, really? Really? We're here now. Shocked every single time. And it's going to happen here too. It's going to happen here too. There's going to be things we don't know. We're going to get into trial when this starts in August, and we're going to be here together till November. And there will be days where we're like, really? And then there will be days when we're like, really? So thank you, law nerds. I know it is hard. These are great for your mind. Look, think of it as brain exercises. Trying to keep an open mind, despite how you may feel, is a great exercise, because we all have feelings. We all have feelings. We all have thoughts. We all have feelings. We all have opinions. It's being able to hold those and hold an open mind that is incredibly important. And that, I think, is an intellectual endeavor that is worthy of us all. So with that, we are going to play the intro. We're going to go to live court. I've got some snacks. I've got some coffee because Dr. B brought it. I had a call this morning. I've got 5 vats of water. I got my Law Nerd hat from the Law Nerd shop ready to go. I got my app notification. Like, I'm ready. I've got sour Mike and Ike's for later in the day. Those things are so damn good. They're so good. Don't tell Dr. B. He hates gummy candies, but they're delicious. Sometimes sour candy is what you need to stay awake in long court days. Let's ride, Law Nerds. That's not the intro, Emily. Emily, what? Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it. All right, law nerds, grab your snacks. It's going to be a long day in court. We're probably going to have to take a lunch break at some point, but let's go. Let me know how the sound is. And we do restream this through our Law Nerd TV channel so that we can have closed captioning for all of our law nerds. So if the closed captioning disappears like it did yesterday mysteriously and I don't catch it, just let me know in the chat and we will fix it because I want the closed captioning as much as you do. Oh, we've got 4 boxes today. Oh, Judge H, hold on. We got it. We got to move. I'm going to hang out down here with you today, Judge H.
Sorry?
He didn't call the case yet.
Oh, I am so sorry. I thought you said
He didn't call the case yet, ma'am. He's like, good morning, Your Honor, ready to rock. And he's like, I have to do judge work. Everybody's ready to roll today. She's just like, I got it, Your Honor. I got it. Let's go. Let's go. That's funny. We know they're ready.
Your Honor. First, hang
on a second.
Oh, sorry.
Haven't called us to order
yet.
yet.
I am so sorry. I thought you said sorry.
I said, let's bring the public in.
Okay.
I appreciate the eagerness, though. All right. Are we broadcasting, Sandra?
They probably spoke
in State v. Kohberger, CR0124.
Before it was streaming.
31665.
That's funny. I like this
Defendant
so
is
much.
again present with counsel, Ms. Taylor and Ms. Massoff. The state is present, represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. This morning's hearing will discuss the motions to suppress and any
I was just trying to move the closed captioning.
Evidence related thereto, as well as we'll get into the argument on that. So
different hearings than yesterday.
I understand the parties are prepared to proceed. The defense, do you have witnesses to call this morning?
We do, Your Honor. We have 2.
All right. Who's your first witness?
The defense bears the burden on these motions that they are making, which is why the defense is going first, calling witnesses, and then they will have the opportunity to do a redirect. You always get to see with defense attorneys where sometimes you get a little bit of struggle between doing cross-examination, which is that 90% of that number has not been vetted by anyone, is the substantial amount of how they question, and then having to switch your questioning style into direct examination, which they don't do as much. This is just a hearing, so you're going to see some leading being allowed more than you would see in a trial because the goal is to really get the questions in there. We'll see how much the prosecution objects. I don't know what we will see from that, but we're going to have witnesses, which is why we got the 4-box layout. And look, if all the courts want to do what Idaho's doing, where the court broadcast it themselves with all of the microphones and stuff, I'm not mad at it. I mean, I'm not mad at this layout. I'm really not.
Corporal Brett Payne.
All right. Let's get going with that then. If Corporal Payne would step.
All right, Corporal Payne. I have a suggestion for alternative careers when you retire, Corporal Payne.
As I recall, but
I've been reading too many spicy books.
Just for formality's sake.
You guys remind me to tell you a story about my mother-in-law later, probably during a members only. All right.
Good morning.
Day 2.
Could you please state your name and spell your last for the record?
Brett Payne, last is spelled Payne.
It's
what's
fair.
your
It is
title?
early.
I'm the detective corporal for Moscow Police Department.
Can you
Yes.
tell the court, I know you
Yes,
testified
indeed.
yesterday, but it was a different hearing. And so just to lay a little bit of foundation, can you tell the court your background in law enforcement?
So I've been with Moscow Police Department for almost 7 years now. Prior to that, I was in the active duty military for 6. 3 of those were as a commissioned officer in the military
Thank
police.
you for your service, sir.
What is your role in this case?
I was assigned lead detective in this particular investigation.
And so as lead detective, can you explain from your perspective, what that has meant that you have done.
He's read
Certainly.
thousands.
So
of
it was my
pages
responsibility to
of
basically
everything.
view this investigation from a 30,000-foot view, if you will. Direct the teams that were assigned to various tasks, and then take in all that information, synthesize it, put it back out to our group, and then eventually consolidate it into an affidavit.
Oh, he's so clear.
And in terms of that affidavit, yesterday there was some discussion and testimony about that and how it was created.
Pause. We did not hear any of that testimony. So for all of you going, where was this voice yesterday? I know. Sealed. That was part of the sealed hearings yesterday. We did not hear from any witnesses yesterday.
Would you explain that?
Absolutely. So the information was brought to us via various teams and specialists in their particular areas. For instance, most of the cell phone stuff was covered by Special Agent Balance from the FBI. All that information was brought to the team, relayed back out at least twice a day. And then as that information was essentially synthesized, it was put into a running document, a living document that is now known as Exhibit A.
The working doc. Right.
So when it was characterized yesterday as a group effort, do you agree with that characterization of it?
Yes, ma'am.
And do you know approximately how many warrants you worked on in this case?
I don't, ma'am. Several. I don't know the exact number.
I'm going to walk you through several segments of different warrants.
I promise I'll stop
and,
messing with my own layout soon.
Some of this may seem choppy, but I'm going to try to do you and then Detective Mowery at once instead of bringing you back and forth. Does that make sense?
Yes, ma'am. Sounds good.
All right. And Judge, I have paper exhibits for you and for the witness. And so I'll go as fast as I can, but I want you to be able to look at what he's looking at. So we're going to begin with the first AT&T warrant.
TN in the chat said he sounds like the voiceover.
Prior to this
in the
case,
A-Team intro.
had you ever
Yes.
secured an AT&T warrant?
No, ma'am. I don't believe I had.
I know I'm the judge's research
And
attorney at this
so,
point. I'm sitting there
given
like a law
that,
clerk.
Who did you rely on in creating the warrant? For
Largely
AT&T?
Special Agent Balance. Obviously, he's the CAS expert, so I relied heavily on his input.
At the time that AT&T warrant 1 was secured, were you co-located with Special Agent Balance?
I believe so, yes.
Can you, in terms of being more specific, it was December 23rd. Were you two co-located at that time?
I believe so, yes.
And I know
Co-located?
co-located has been talked about in court a couple of times, but can you just explain what it
explain?
means
Thank
for you
you.
two to be co-located since he's from DC?
Thank you,
Certainly.
ma'am.
Yeah, he was in the same building as I was, just mere feet away from the command post.
Okay, so when you say mere feet away, were you guys in like a cubicle setting
military
or
of
were
them.
you in offices with doors? What was this setting in terms of proximity to each other a few feet away?
Yeah, separate offices with doors, but in the same second floor of the Moscow Police Department.
Louise, we're just getting started. You
Were
didn't
you
miss much.
aware of Special Agent Balance in
This is Corporal
his
Payne.
work in doing self AT&T records, having any access to AT&T records without a warrant?
I am not aware of that, no.
Are you aware of him having any ability to review AT&T records through any portal without a warrant?
Not to my knowledge, no.
AT&T has a portal. That'd be helpful. We used to get printouts and occasionally a
I'm
disc.
going to begin with
so
what is
annoying.
known as
portal would be
States Exhibit
heaven.
1 attached to their objection to the motion to suppress AT&T warrant. And Judge, for today's purposes, what I'm doing is relying on the labels that are in the record as opposed to giving them new stickers.
This has been marked previously as states S1, or is that 8-1? I can't.
I think it's SS for state 1.
Sir, I have a question. Under what
One,
circumstances would you or would you not
search
say get in the car, Elizabeth? Just
And now I've got to get,
Objection.
as a question.
to the admission of that
And before you all ask,
you know, Judge, I
yes,
should have started
I'm
out
gonna
by
ask women
saying
the same
that
thing if they have a
the
sexy
same
voice.
stipulation regarding the admission of all exhibits applies today.
we love a good voice.
We do need the formality of moving for the admission, however.
I can do that.
The judge is like,
Do you
yes,
want
we need
me to
evidence.
do that per exhibit?
We need evidence.
Well, it makes, if you're, as you're talking about them, it probably makes sense.
Mm-hmm.
Okay, I've got to get myself S1.
Court's like, can you please just mark them? Did you guys know that Ava Green reads sleep stories in the Calm app? They are so good. They're so good. Love a good sleep. Love a good sleep story. Joanne asked, am I having portal envy? Yes, I am, because it would make evidence so much easier. But I left the DA's office in 2017. So when I first started at the DA's office, there were times when we were doing like cases that involved driving erratically or whatever, where we were taking the Thomas guide and blowing up individual pages and pasting them together on a large poster board. So by the time we got to being able to use computer programs to like map cell
Can,
towers with
Detective
circles,
Payne,
I was like,
can you look at page 5.
loved it.
Ma'am?
On page 5, can you read what it says in the at the very end of the page in the sentence above wherefore that begins with the paragraph? It begins in support. Can you read that paragraph?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
And
Right.
is that S1 the affidavit? And
The 20-page affidavit, the 20-page fact document that the defense didn't talk about a lot yesterday. He said it's in all of these affidavits incorporated. So the affidavit is an overview, and then there are 20 pages of other shit. Right.
in support of the search warrant?
Yes, it is.
And by fact document,
And
it's
that's
facts as they know them.
AT&T one search warrant that was the first one served on December 23rd, correct?
That's correct.
And that language that you put in there, Exhibit A, is incorporated as though fully set forth herein. Is that the language you just read?
Yes, ma'am.
The judge is looking at her like, can you go faster?
Right.
Please.
I'm now going to hand you State's Exhibit 2
Rolling
to
wrong,
the
long,
Apple,
same.
to the AT&T first warrant.
Orlando was so easy to listen to. We all just sat here and went, oh, look at you and your opening statements. We love you. Not getting to see Orlando do a closing in that case is something I'm very sad about.
Can you review that first page, the first paragraph?
Smurfana asked, what happened to the male attorney that works with Ann Taylor? He's been in and out. He was there yesterday, but these are not his motions, so they are splitting up work. But generally when attorneys split up work, it's
Pardon?
a good group assignment where it's like you're just in charge of this
I am
whole
seeking
part.
the admission of S2. Just to be clear, Judge, all of these that I'm putting
So he
before
doesn't
him
necessarily
and
need
the
to be there.
ones that are attached, we're seeking the admission of.
Objection to S2. All right, it's admitted.
Have you reviewed that, Detective Payne?
Santa prosecutor.
Do you
This does
see
not look
that
great.
the language that I just referred to in the search warrant affidavit? Do you see that same language in this warrant, in where you incorporate the affidavit, incorporate Exhibit A into your? You see that language
Ma'am.
in S2, and is S2 the actual search warrant for AT&T?
Yes, ma'am, it is.
Michelle
Can
asked,
you turn
can
to
you do
the
a roundup
last
of both days
page
for quick bits?
on
Yes, we're going
page
to.
4?
We will do a roundup of both days for quick bits. Santa prosecutor was there yesterday. It sounded like he didn't feel
What
great.
time was the warrant served?
10:03 a.m.
This is AT&T warrant.
Do you recall that the return on that warrant came in at 3:30 that day?
That would sound correct. I don't remember specifically.
Would
Hey,
it help
that's
if I showed you the AT&T mobility propriety front page to verify?
okay, I can't. Chat,
Judge,
you're
I'm
right.
not seeking the admission of this, just for purposes of him being able to be.
Vicky with an
certain.
eye, can she talk faster, please? I am taking that as a motion for 1.25 speed, and we are going to
Show the docket
1.25
to
speed
refresh his recollection.
until we get past foundational questions. Yes, we are. We are now at 1.25.
Yes, Your Honor. And Judge, for the record, this has also been admitted already in Frank's D17, page 634. Detective, can you see on that that came in at, I think it's 15:30? It's,
15:31.
okay, thank you.
They were refreshing his recollection, meaning he's like, I don't know exactly what time this particular search warrant was returned. It's
I'm
important
now
to her for
handing
some reason.
you
So
Defense Exhibit A
3:31.
to the reply to the AT&T suppression motion.
why? He didn't write that. The court already has it.
This doesn't have a sticker on it.
Pardon?
This does not appear to have a sticker on it.
No, it does not, but
It's
it
already
is
filed.
attached to the reply as Exhibit A, AT&T. And that reply is, okay. Can you see line 4 there? Oh, sorry, Judge.
Copy and put, let's just, do you have a number that we were going to call this?
I would call it Exhibit A to reply, because that's what it is in the record. You see at the bottom of the page where it says Exhibit A, AT&T?
So this is the return of the warrant of S2.
Yes.
Right, let's call it S2.2 or 2.1, pardon me.
That's the
That's fine.
warrant return.
Fact that it's associated with that particular warrant. Allowed to touch stickers under the
Warrant
contracts.
returns are what comes back after you serve a warrant. So you serve the warrant, and then the warrant return says, hey, it got returned with all of this stuff. So it tells the judge, and those warrant returns go to the judge that signed the warrant, amongst others. But the warrant return says, hey, this is what we got.
Detective
And
Payne, on page
it closes
2
the
of
loop
that
on that warrant
Exhibit
being
A. It's
outstanding.
actually just the front page where it says affidavit of Brett Payne. What does paragraph 4 say?
Paragraph 4 or line 4.
Line 2. Line 4.
Says the warrant was served on 12/23/2022 by email, fax, etc.
So do you know exactly what method was used?
I don't remember.
Okay. And it says warrant in that line, right?
Yes, ma'am.
Does it say anything?
Ma'am, you're going to have to go a real long way to convince me that there is a substantial or significant difference between email and fax in this context. Because even if it was technically served by fax, it would still be kind of served by email. And it's going to depend on the cell phone provider, how they receive search warrants. And even if it is by fax, somebody's going to put it in a computer and then send it to fax. Does it matter?
About the affidavit in support of search warrant accompanying the warrant.
I know this is the
next page,
sausage part of how court goes.
Receipt and inventory of warrant. Do you see that?
Yes, ma'am.
Can you look at description of property? What does that say?
It says 509-592-8458.
Can you explain how that's a description of property and what that means?
It's a phone number they're
Just
searching
means
for.
essentially that there was the information retrieved as a result of that phone number being queried with AT&T.
That's the property. The property is the phone number account.
And it indicates that that was produced how?
Entrance was obtained by email.
And when that was received, did you do anything to verify that the data was within the date ranges of November 12th to November 14th of 2022?
I don't remember. That information was provided to Special Agent Balance as soon as it was received.
Do you have, when you say that it was provided to Special Agent Balance, is that because you don't have the capacity, technical skills, I guess, to review that raw data and do something with it?
Yes, ma'am.
Ma'am, you got to be careful with the way you say raw data
Was
because
there anybody
I
else that you relied on
thought
for
you were
that
going a
other
different
than
way.
Special Agent Balance?
Not that memory brings to mind.
Let's now turn to the AT&T 2 pen trap and also known as pen trap and trace. Can you explain what a pen trap and trace is?
So
These are
pen register,
interesting.
best of my knowledge, now granted, as I've stated before, I'm not an expert in cell phone stuff, but best of my knowledge, a pen register tracks incoming and outgoing phone calls, text messages, so on and so forth. And then the trap and trace is the portion that essentially gives you location data, or the precision location data rather. So it's essentially incoming and outgoing calls, what messages are received, and then part of that was where that phone was located.
Was it required that you secure the AT&T first warrant to obtain the second warrant that included a pen trap and trace?
That's
I
a
don't
good
believe it was
question.
required.
So when the
So why'd you do it that way
data
then?
was received on at 3:30, you gave that data was given to Special Agent Balance?
Yes, ma'am.
Okay. And then what
We're gonna hear from
happened
Balance,
in
I
between
imagine.
3:30 and 4:53 when the second warrant was secured?
Are you talking technically speaking, or can I speak in generalities? Because that's all I really know.
Well,
Generalities. I'm going to slow this down because I'm curious too. What she's asking about is the fact that there were 2 search warrants for the phone company AT&T. The first one was actually really limited in time, which is an appropriate search warrant, just November 12th through November 14th, 2022. Then there was a second search warrant, an hour and a little bit later. And with that second search warrant, they asked for more information and the trap and trace. He is not the cell phone guy. He has said it. I did a lot of the cell phone stuff at the DA's office because I am a nerd and I like technical stuff. And some of the other lawyers were like, ugh, I don't want to do anything with tech data. And I'm like, I'm the nosiest bitch in the world. Are you kidding me? I'll go through somebody's bank records. Let's go. So I love this stuff, but what happened between the very narrow first search warrant and then the second search warrant? But I think it's probably the other witness that learned something because something happened. Funkarella in the chat said, Pain and Balance sounds like a chiropractic clinic.
you talk about what you know.
So the only thing I know is that that information was provided to Special Agent Balance. He utilized whatever tools he has at his disposal, and then it was decided upon to go after the second pin trap and trace.
When did you start drafting that second trap and trace?
I don't remember.
So on that day, you did one in the morning
Sounds like it was a busy day.
that was secured at 10:03,
Yes, ma'am.
and then the second one was secured at 4:53 p.m. And you don't have a recollection of when you were working on those?
I don't remember.
Toya, this is just to try to suppress the search warrants. So today's not everything, but the search warrants encompass quite a lot of evidence. So they are again going for that
I
chain
think you have State's Exhibit
and
2
trying
in front of
Yes,
you.
ma'am.
Can you go back to that one?
break the different links in the
Can
chain.
you see on page 1,
Sing along in your head.
what does it say that the time of that warrant was obtained?
And if the link is broken, then everything that comes after it goes with
State's
it.
Exhibit 2.
So if you get rid of the search warrant for AT&T, you can get rid of all that data. When we get into the Corey Richens case,
1003 is what it says. Is that what you're referring to?
we'll talk
No, I'm
about it.
Referring to the return, which should be in, I might be referring you to the wrong exhibit.
Point 1, I believe.
In the Corey Richens
And that was
case,
at 4:53, the second
man, I'm
warrant.
just going to stop you there. In the Corey Richens case, she gave them her PIN code so they could get into her phone, and they did a cell phone extraction with it, but they also did a cell phone extraction without it, just in case there was an evidentiary issue with regard to them using her PIN code for her phone. So they did it both ways. It's just like with the FBI being like, hey, technically we could take your trash cans off the curb, but it's even cleaner if the trash company comes and picks it up, because then the defense can't argue, well, they could have brought their trash back inside. We don't know if it was really abandoned yet. It just eliminates all of those arguments. So you'll see in this investigation, I think there's a lot that they did to try to eliminate those arguments, including, look, there could be an argument here, so we're just going to go to the next step further. So there's absolutely no argument. And that is what you want to see in investigations. Instead of just being like, it'll be fine. Be like, not only will it be fine, but we know we are squarely within the bounds of the law and we're going to go a little bit further and do the extra work. And that's really what you want. You want them to do the extra work, not bust out a snowblower and be like, it'll be fine. It's very different styles of investigation.
Warrant was obtained at 4:53. I might not have handed you pen trap.
I don't think I have that one.
Yeah, my understanding is, just so we're clear, because I'm getting a little confused, is that we have the affidavit for warrant.
Man, what
the
are we talking about?
Warrant and the return of the warrant, all related to the first warrant to AT&T. And we haven't got the pin trap and trace warrant presented yet, I don't think.
Right, I've got it
Correct.
here. And Judge, for clarification purposes too, today as we're going through testimony, my plan was not to go through every single warrant that we're arguing about and
Right.
get it in front of the court. I'm really trying to take kind of a scalpel approach on the issues that we want to point out to the court. So it does really feel like I'm jumping around, and I realize that. I hope to bring it all together in the end.
I hope so too. We'll all
One
be
caveat being
optimistic.
What I've told you before is where you have as a broad array of documentation that you've presented. The court will not scour the record to find support for your motions that's not pointed out to the court specifically. And that's well established with case law from the Idaho Supreme Court.
And Judge, that's why I am trying to grab
The
the
judge is like-
pieces and parts that I want you to be able to identify. And that's why I'm putting the paper in front of you.
Another day, I'll tell you how
So
I
I'm
prep
hearing
this
you
kind
when
of
you've
stuff.
asked us to do that. All right, I'm handing you
And yes, we are
State's
sped up.
Exhibit 1. And this is to the second AT&T warrant, also known as Pin Trap and Trace.
That's asking for more information.
This one is also listed as S1 on the sticker.
Oh, shit. There's already an
that's
S1.
Going to cause some problem, I
It's-
suppose.
It's S1 attached to a different motion to suppress.
Because there's 13 motions.
Well, hopefully we can figure it out when we're looking at the entire record, but
Yeah. And what I think, Judge, when you are going back and working with your clerk,
my concern, frankly, I know what all the documents are and what they relate to.
The appellate
My
court won't.
concern is a reviewing court's ability to understand what you're talking about in court today
Yep.
and trace it to a stack of documents. That's my concern for this, so.
and I understand that. And so in preparation for today, I mean, I really did think, do I need to go through and read, label all of these?
He doesn't need to know your
And I
thought
thought that
process.
would create more confusion in the record because these are all attached to specific motions with these
You
labels.
thought wrong.
This is marked S1, titled Affidavit for Search Warrant and Application for an Order for Pen Register or a Trap and Trace Device.
Yes.
So on the record, what we're looking at.
So Detective Payne, is that the warrant that, that affidavit in support of the search warrant that you drafted for that
Terry needs coffee.
second
Good to see you on the chat.
AT&T warrant?
There are different ways to organize this for court. This is not the way. These attorneys have lots of work to do, but you have to be prepared for hearings like this that are going to take 2 days with this judge.
On page 11,
This is where binders come in helpful. And highlighting and color tabs, and then you're going
at
to
the
have
bottom of the
a
page, can you
entire,
read
like-
that last sentence under probable cause.
Certainly. In support of the assertion as to the existence
Table
of
of
probable
contents.
cause, the following facts are offered based upon personal knowledge of the affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
I'm waiting for her to get to the point she wants to make versus the
All right, I am now
Foundation.
handing you S2. which is the search warrant and order authorizing installation and or use of pin register trap and trace device and non-disclosure order pursuant to Idaho Code 18-6772.
If you want to know about how much information can be gotten about your phone, I wonder how much we'll get into the pen trap and trace, but if you don't know how much information can be gathered on you, I think it's probably good to know. Oh yes, I had things color-coded. And those accordion binders I used all the times. Depending on the witness, I would have an accordion binder per witness with everything I would
Can you
need to bring
please
in for that
turn to
witness.
Page 7.
And then I would have a table of contents of all the documents, and I would have 3 copies of all the documents, if not more. The one I wanted to use, the one I needed to give to
Can you
the
see what
witness, and the
time
one for
that
the court.
was obtained?
4:53 p.m.
Tash, yes, yes, I have the type of ADHD where office supplies are one of my hyperfixations. And my colleagues and I would, well, particularly Judge Abby and I would be like, can we go to Chipotle and then go to Staples at lunch? Yes, we are on 1.25 speed.
I'm now handing you what is titled Return of Search Warrant, Exhibit A to
Yes,
Trap
she
and
was,
Trace.
Brandy. I saw that too.
Does that have a sticker on it?
Pardon?
Does that have a sticker on it?
No, it does not.
I love that Robert's like, 'tis the tism and it's a superpower. I have not explored the rest of the end of my neurospicy spectrum, Robert. But there are definitely
What do
behaviors
you
on
call that, Judge?
a variety of
Dash
the
2.2.
spicy spectrum
Dash 2.2.
that I recognize.
Further delineated by the title, which is related to the pen trap and trace.
It should have probably, sparked some curiosity when Dr. B and I, in our initial dating, would just spend hours telling each other about our different hyperfixations. They often centered around
On
work.
page, can you look at page 2? You see the top, who does it say it's the affidavit of?
Corporal Brett Payne.
Are you looking at Exhibit A,
It's going to
page
say
2?
the same thing.
Correction, I see what you mean. Affidavit of Lawrence Mowery is what it says at the top.
Right, and then but is that actually your
It is, yes, ma'am.
affidavit?
Oh, Nishay, all the
So was-
time.
That was a mistake.
Yes, ma'am.
I'm sorry, what were you looking at?
On page 2, the top of it says affidavit of Lawrence Mowery.
Oh, gotcha.
It's the affidavit of Corporal Payne.
Heading problem there.
Buffy, I am fun to go school supply shopping with because I have the patience to let Griffin zip and unzip all of his things to see which zipper does not offend his sensory quirks. So yes, I think a lot of parents would be like, well, parents who are not also recognizing their own neurospiciness would be like, wait, what are you doing?
And
And
now
Griffin's like, this
handing you
zipper makes my brain
Exhibit
happy.
C
Yes.
to the reply to Trap and Trace. It does not have a sticker. And it says AT&T Mobility Carrier Request Form.
This again relates to the trap and trace warrant.
It does.
Can we talk about what was returned on the trap and trace warrant?
S2.3.
Pamela said, did I miss anything? No. We're marking exhibits and talking about office supplies.
Next day or so, if you would
We're on 1.25 speed.
identification list, if you will, of the exhibits that you'd stipulated to admission to yesterday, as I don't think we went through those individually, just so that there's a record of that.
We can do that.
The court's like, can you please
Might
organize
discuss
this into a list? Because God damn it.
Can you look at, are you looking at that Exhibit C, Detective? Was cell site location data requested for this warrant on this page? And was a timing advance report requested on this page? I'll refer you to the last paragraph where it says remark special instructions.
What's hard for the judge is his brain moves faster than this.
Yes, ma'am.
Our brains move faster than this. And we are at the most foundational level of foundation.
And do you see any reference in this document indicating that the affidavit in support of search warrant was included with the warrant?
No, ma'am.
Okay, the next warrant I want to talk about is Apple.
Okay. Yes. Oh, no, I might have gone back to normal because I wanted to hear if he was going to talk about pen, trap, and trace. Thank you, chat. I did go back to normal. And it was still, it was painful. Okay, we've sped up. The sweatshirt I'm wearing is Lululemon. It was on sale. It is the scuba hoodie. It is cozy. And it has thumb
Prior to
holes.
this case, had you ever prepared an Apple warrant?
I cruised the sale
I
section.
don't remember.
What was your training
There we
related
go.
to Apple warrants in December of 2022?
I had no official training at that time.
Yeah, the tech wasn't his shit. That's why they brought in.
I'm handing you what's
deal with
been
it.
marked as Defendant's Exhibit A. It does have a sticker, and it's to the Apple motion.
They're going to go through and admit every single one for 13 warrants because they've got warrants for Apple, Google, Apple bottom jeans, boots with the fur. No warrants for that.
Can you state what that document is?
Apple, Google, Amazon,
Appears to be a
AT&T.
preservation request.
And who is it sent to?
Apple Corporate Legal Counsel,
And what's its date? What is it? What is the date on it?
December 21st.
Of 2022.
Correct.
And that letter was not sent by you, right?
No, I do not remember sending this. No,
Well, can you look at the,
that's not me.
yeah, the top of it is Department of Justice, and the back, page 2 is Special Agent in Charge Dennis Rice.
Correct.
There is nothing wrong.
How was the DeSales email account known at that date?
I don't remember.
There is nothing wrong with multiple people working on all this in a case like this.
How did you become aware of an Apple product in this case?
Memory serves, when
With
the
our
search warrant in
eyes.
Pennsylvania was executed, there was an iPad that was located in one of the shared living spaces in the home. And there's a receipt in his vehicle, in Mr. Kohberger's vehicle, that was found for an iPad as well.
And during the home search, was the iPad seized?
It was not.
Why not?
It was in a shared living space.
Do you remember what day that the Apple account was created?
I don't remember.
That's
No, ma'am.
positively restrained.
2016. Sound familiar with the research?
That sounds vaguely familiar. Yep.
And you mentioned the
In a shared living space, you can't always determine who owned the thing unless you had more specifics. If you knew, because you would see me on stream, that my current phone case is green with the gold dragony pop socket or whatever, and you knew that because you'd seen it on stream, and then we're in a shared living space and saw this, you could say, I identify it as being her phone because she has held it out to be her phone. But just an iPad in a shared living space could belong to him, could belong to his mother, could belong to his father. And depending on what their warrant was for, you can't just grab things that could belong to different people. So they did not grab the iPad because it would A, cause evidentiary issues, and B, potentially go beyond the bounds of what's written in their search warrant because it's not readily apparent that it's illegal. Now, if it's in a shared living space and it's something that is illegal and you can tell that by vision, like cocaine or meth or whatever, it's an easy example. You can seize it out of the joint living space because it's in plain sight. So look, Fourth Amendment search and seizure is an entire ass law school class and sometimes multiples, but that's why they're not seizing it from the shared living space. What I imagine that they're going to do is once they got the receipt, they're going to look at IMEI numbers. They're going to go through iCloud accounts. They don't necessarily need the physical thing, but this is from the house in Pennsylvania that is Kohberger's parents' house, because that search was from that home. And in like a living room, you don't know if that's Kohberger's iPad, mom's iPad, dad's iPad, somebody else's iPad. You don't know. So
The receipt that was found in his car.
Shay, they
Do you
have them
recall
with
the date
hoods.
that indicated
They do
that
have them with
an
hoods.
Apple product was purchased?
I like the version
I
without the
will
hood,
show you State's Exhibit
but they do have them with hoods.
1.
So that's why. Laura said my mom's and mine
The
laptop
affidavit
reside in the
for
same
search
room.
warrant.
Perfect. No search warrants. Spark, that's what I'm here for. Spark said, that makes sense. That's what I'm here for. Look, I don't assume all of you have taken like multiple classes of criminal procedure, because why? But there's a lot of nuance to
And I
this, and there's a
believe
ton of
that's
case law to it,
tabbed, the receipt.
especially when we're dealing with homes and joint living spaces and multiple
State's
people in a
Exhibit
residence.
S1 affidavit for search warrant to Apple Inc.
Yes, we're still talking about the Apple search warrant. I just want to know what's in the search warrant returns. Like, what did you get?
It's 2018, the date.
Yes, ma'am.
A, B, C, D, E, F, G, S. Couldn't you check for fingerprints? Not if you can't seize
Where
it.
did you get the form to prepare the Apple warrant?
The
You
form,
would have to seize it first.
to be more specific.
Correct. Well, the search, so you're looking at the search warrant affidavit, and inside of that affidavit is a long list of items that you request.
Yes, ma'am.
Where did you get that information to be able to?
Hold on. What the L asked a good question in the chat, and a lot of you are asking similar questions. What if you commit a crime and live with multiple people? It very much depends on what's known, the circumstances, what the thing is, what's seen. There are law books full of cases about those situations. There is a case where what if you are searching for a weapon of a certain size, and then you pull open a drawer that clearly could not fit a weapon of that size, and then see something else and take it, like a piece of mail that might be relevant. You can't do that because now you're searching where the thing you had the warrant for doesn't fit, and you can't just go opening drawers if they don't fit. But you could open underneath like a sink to look, because then it might fit. And there is a lot of case law about if you're targeting something, like an iPad's part of a crime and it has a particular IMEI number on the back, then you might be able to get to looking at that iPad to determine if it's the right one or if it has a unique case, or if somebody sends a message and the iPad lights up and it has a photo on it that shows it might be theirs. There are so many different what ifs, and they're all very fact specific. And this is where research comes in. But for law enforcement, and I think the FBI helped execute that search warrant, to be trained enough on the Fourth Amendment to know that the iPad being in a common space is an issue is good, because some law enforcement do not do that well and would be like, meh, we are here to get digital evidence. It seems like it'll be fine. And then that'll get suppressed down the road. So they will go about this a different way. And that's what they're going to do. So let's continue.
Include that.
That was all provided to me from the experts in that particular field.
This is a complex area of law on what you can take, because we don't want the government just coming into your house and being like, I take shit now. Like that we don't want. So this is a complex area of law, as it should be. You can't just take whatever you want. You can't just search wherever you want.
I'm just getting S1 in front of myself for a minute here, Judge, so I don't, or I'm gonna have to give him.
On the top of your mouth should be, do you have a warrant for that?
Are those when you said the long list, are you referring to paragraph B on page 2?
On page 2, beginning on page 2,
Is that what you're referring to?
I'm referring to everything A through I.
Sherlock,
That was
Mom, you're
okay.
welcome.
Question pending. I kind of threw
It
us,
is nuanced.
down a side alley there, so I apologize if there was a question pending that I threw you off from.
No,
No,
that's
you
fine.
didn't.
I'm looking for the,
You didn't throw her off from anything, Your Honor. She's still looking for what she wants to introduce into evidence next. The thing that's frustrating is A, they've been preparing for these motions from November. B, they wrote these motions, so these motions are theirs, so they knew what information they needed to get in. And C, they know what order they're
do
asking
you
them in if they're
recall that
witnesses.
in your affidavit?
So it should be in their folder
There's reference
in
that
order.
iOS devices can use an iCloud account to back up the iOS device.
Yes, ma'am. That sounds familiar.
And what is it, what's your understanding when an iOS device uses an iCloud to back it up?
Similar to Google and many other of these
Yes, they got the
digital
iCloud
operating
account
systems,
here.
essentially they back it up to a cloud account. That information is stored not on your device only, but also in a cloud storage area. That's my understanding of it.
And they
So
took it.
in an Apple phone, that ends up as creating a duplication of what's on the phone.
Essentially, yes.
And do you recall that in the affidavit, you made reference to the fact that Apple users get 5 gigabytes typically of storage and then can purchase more?
Yes, ma'am.
Yeah. Is there, counsel, where's the problem with the affidavit though? For those of you asking what Ann Taylor is doing, probably working on something else because this is not her motion. So I imagine she is working.
I'm handing you what's been marked as Exhibit D to, it's Defendant's Exhibit D to the Apple memorandum in support of suppression. And it is it does have a sticker.
Just like Santa prosecutor's probably working on something else.
All right, it's marked Defendant's Exhibit D, date 11/14/24, entitled Affidavit for Search Warrant directed to Apple Inc.
My kid's personal Uber driver said, I don't understand what's going on
Can you
here. They're
please
marking
turn
exhibits
to page 27.
for their motion to suppress. And asking specific questions about the search warrants for the motion to suppress. We're on the Apple search warrant.
The actual warrant itself that you're,
Yes.
yes, ma'am.
Well, it's, I don't want to answer that as a yes before I look and make sure what this exhibit is.
Want to make sure because my page numbers run out at 25.
It's Exhibit A. And it's to the Apple warrant.
Exhibit A
It
is on
says so.
all the
Exhibit
warrants.
D, Apple, the bottom map page says page 27, but above that it says page 23.
I'm there.
Okay. At the top, it says on January 27th, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested records.
I'm not there, so can
Oh,
you
I'm
give me some
sorry.
direction? Are we looking at
Exhibit D,
D?
yeah, page 27 of my marking date.
So there was a search
So
warrant
it says
return.
Exhibit D dash Apple dash page 27.
On January 27, 2023?
Yes.
All right, go ahead.
Yes. On January 27th, 2023, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested records. Can you explain what Apple responded to?
I don't remember what all they responded to. They responded to the search warrant and all those listed items that were in the warrant itself.
And the warrant, the date on this, if you will turn to,
Are you saying that the search warrant return wasn't specific enough? Is that what?
turn to page 34 of the exhibit. Do you see the date of the warrant?
1st of August.
So I understand that you just said you don't know or you don't remember, but in this context, in your search warrant affidavit, you make reference to something being produced on January 27th to process to get a warrant in on August 1st. Do you know what the process was that Apple responded to or what they produced?
I do not remember. No, ma'am.
Well, there was an Apple warrant on December 21st, 2022. It would seem to follow that the search warrant return from January 27th, 2023 is the return on that. But the return should spell
I'm
out what's
handing you
returned.
Defendant's Exhibit B
But I don't think it was returned
to
to
the
him.
Apple Defendant's Memorandum in Support. It does have a sticker on it.
So
the exhibit, just for the record, is Defendant's Exhibit B, date 11/14/24 on the sticker, and the title is Certification of Apple Inc. Custodian of Records.
Detective Payne, on this, there's a certification, this document is a certification of Apple Inc. Custodian of Records. Do you see that?
Yep.
And it indicates that records are certified and being produced from legal process served on Apple on January 12th, 2023.
Ma'am.
You see that? What was served as legal process on Apple on January 12th, 2023?
I don't remember.
You know
It
what
would
the
be-
legal process would be?
It would be documented somewhere.
I don't remember what that would have been.
And if it's not, then it's either a problem or a date error, but we'll see. I wonder if the FBI did it
Going back to, we're on, going back
because
to
they were
Exhibit
doing
D.
the
I have
data.
that one in front of you still.
Yes, ma'am.
Can you turn to page 35 of that?
Amy L in the chat said they're trying to suppress what? All of the search
On line
warrants.
4,
Well, that's not
What does it
technically
say?
correct. They are trying to suppress all of the evidence gathered from the search warrants. So they are going to be going through different search warrants, their motions that they filed in November, and we went through those on a different stream. We didn't go through every single one because they're largely the same, but they are seeking to suppress the returns from search warrants to Amazon, Kohberger's apartment, Apple. They're seeking to suppress the arrest warrant, the warrants to AT&T, the warrant for all the cell phone data, the pen trap and trace, which is the second AT&T, everything from Google, the warrants with relation to the search of the person in Idaho and in Pennsylvania, the search on the white Hyundai, and the search on the home in Pennsylvania. So those are the broad topics that we are going over today. They are going through the concerns that they have, which is, okay, there's a return from Apple on January 12th. What did you ask for? I don't remember. Okay, well, where did you ask for it? But some of it was done by this corporal, and some of it was done by the special agent, who I imagine is going to testify next.
Warrant was served by Corporal Payne on August 1st, 2023 via law enforcement at apple.com.
and so that would have been the Apple warrant, right?
Correct.
And you served it, right?
I believe so.
Apple bottom.
Well, when you say you believe so, would you have executed an affidavit if you hadn't?
No, ma'am, I just want to make sure on the warrant return itself that it wasn't served by one of the digital forensics folks.
This affidavit is your affidavit, and on line 4, it says you served it, right?
Yes, ma'am.
Did you serve that with a copy of the search warrant affidavit?
No, ma'am.
Was it your practice in serving all of these warrants that where you actually did service, that you would serve the warrant only?
Yes, ma'am.
Well, right. He doesn't need to serve the affidavit to the warrant.
And then on
He just needs to
Exhibit
serve the signed
D,
warrant.
page 37,
For those asking, trial starts
at the
in
bottom
August.
where it says description of property, can you explain what the return was for that Apple warrant?
It's going to go through
All account
November.
information associated data for the following Apple identifiers, and it goes through DSID, Apple ID, v Kohberger at spartan.northampton.edu, another DSID and Apple ID
I'm going to slow
Wi-Fi.
this down because he's rattling off what was searched for, which I think is always interesting. We went over some of it, but some of it's sealed.
The return was for that Apple warrant?
All account information associated data for the following Apple identifiers, and it goes through DSID, Apple ID, v Kohberger at spartan.northampton.edu, another DSID and Apple ID Wi-Fi Armiones at yahoo.com.
So multiple
Did you
Apple
open
IDs.
up the
and
Apple
associated
data
accounts.
and examine that?
I don't remember if I looked at what the return, like all the files that were attached were.
In terms of evaluating that Apple
We're going
data,
back to 1.25.
as the lead investigator, who have you put in charge of evaluating Apple data?
I relied on the specialists in those fields, which would be Detective Mowery and then S.A. Balance. Those are the folks who knew far more about it than me.
The tech people.
Do you know, as we sit here today, whose job it is to evaluate the Apple data for this case?
I don't know, ma'am. Not right now.
Okay, the next warrant we
And
will
if y'all
talk
are
about is
asking,
Google.
isn't he the IO? Like, isn't he the lead investigator? Yes. But without his full case folder and with this being a multi-jurisdictional case, at this point, his answers are going to largely be without his case file in front of him. I don't know who took over the tech. It was either the special agent who's handling it or the special agent gave it to our local tech experts.
I'm handing you what's being marked as Defendant's D
Laura,
to
he
the
took-
Google memorandum.
he gave the tech data to the tech investigators. So there are going to be like co-lead investigators, and he's like, I'm handling this part of the investigation. They're handling the tech part of the investigation. So you need to go to the top of the tech team, because I don't know if it's him or somebody on his team dealing with it. Just like sometimes you don't know who in the chain is handling it, and he's not going to answer imprecisely. And there are other witnesses to come.
In support of suppression.
So this is laying foundation for all of the affidavits.
Right, so that I'm clear and the record's clear, this is Defendant's Exhibit Number D with the date on the sticker of 11/14/24, which refers to the sticker date, I believe, not necessarily the document date. And then it's entitled Return of Search Warrant, the warrant being with respect to the application of search warrant for Google LLC.
On to Google. Laura in the chat asked, will he be cross-examined?
Proper argument.
Yes, this is the defense
Did you prepare
motion.
the Google warrant returns Exhibit D?
This is the defense attorney.
On page 2 of that exhibit,
So the state will do cross.
does your affidavit say Detective Mowery served the warrant through a portal?
Yes, ma'am.
How did you know that?
Told me that.
When did you get the return? When you got the return, did you review the data?
I did not, ma'am.
Did you take any steps to see if the return conformed to the warrant?
I did not look at the technical data it contained within. I believe it was a zip file that was downloaded from Google, if memory serves me correctly. I downloaded it and made sure that that was there.
And do you recall that there were actually 3 Google warrants? Does that sound familiar? I'm going to hand you now Defendant's Exhibit E. The Defendant's Exhibit E to Google memorandum in support of motion to suppress.
All right, Defendant's Exhibit Number E, again with the date on the sticker 11/14/24. This is a receipt and inventory of warrant to Google.
So that's the return.
On this document under the description of property, can you state what Google account you put in as received?
Zip files for all digital records for the Google accounts of Bryan Christopher at gmail.com and username spelled a bit different at gmail.com.
Did you know that the email in the warrant is actually Bryan Christopher 1994 at gmail.com?
Oh, that sounds familiar. Yes, ma'am.
So on that description, is that a mistake?
Yes, ma'am.
And did you do anything to, I asked you this, but you didn't do anything to verify that the data that you received from Google fit what was requested in the warrant?
Oh, ma'am. Not to my recollection.
That's it for Google.
So she's saying on the Google return, it shows a slight variation of the name, which could be a Scrivener's
You
or
were in
clerical
Pennsylvania
error,
for Mr. Kohberger's arrest.
but might not be. What's going to matter is what Google says the account says. If Google sent back the wrong account, that won't come in. If Google sent back the proper account, then it will come in, whether or not there was a typo on the search warrant return.
You were in Pennsylvania for Mr. Kohberger's arrest, correct?
Yes, ma'am.
And you watched the preparation.
I'm going to put this back to regular speed because I'm curious about details surrounding the arrest. We haven't gotten a lot of information about that. So we'll see.
For service of the arrest warrant.
How do you mean?
Well, maybe I should ask this more open-ended. Tell us
Direct
about
exam.
your
Go for
arrival
it.
in Pennsylvania in time-wise to his arrest, time frame of his arrest.
I believe we arrived there, if memory serves, about 7 p.m. on the 29th. And I think I get my dates right here. We observed final preparations for the SRT operation that was going to take place. And then we being myself and Detective Gilbertson from ISP, drove to a separate Pennsylvania State Police barracks to await the arrival of Mr. Kohberger.
When you were observing preparations, what were you observing?
So they waited for him to be arrested and come
I
back to
believe
them.
we observed their final tactical brief for SRT, and that was about it.
Can you explain what that was, what the preparations were that they were making when they were doing that tactical brief?
I can give you a general overview as best I got.
Hey, Gossip
So
Squirrel,
had the
hope you're
entire
doing well.
SRT that was going to be conducting the operation present.
For the record.
Your community's been through a lot.
A special response team, usually what it stands for, Your Honor. So they were doing their final preparations, going over their approach, team member assignments, so on and so forth. This was all done via basically a briefing in front of everybody.
And do you recall that the preparations included that in preparation, they were going to knock and announce in execution
I believe that was brought up. Yes, ma'am.
of the warrant? Okay. And while you were there, did you go into and have were you given a tour, or did you drive into the gated community of Mr. Kohberger and see where he was living?
No, ma'am.
You never went in or around
He said he
his home?
waited at the barracks for them to bring Kohberger
When
back.
the
It's not his jurisdiction.
execution of the arrest was happening, did you have the ability to listen in any way?
The only ability that we had at the time was a very choppy drone feed. We were driving at the time it happened, and that was the only communication we had
Driving
And
where?
so how is that choppy
You said you were in the
drone feed
barracks.
being communicated to you?
via cell phone.
So can you explain that? Like, who's the person communicating with you about the drone? I just don't understand.
So essentially, it's a drone operator with their SRT. I don't remember how it was conveyed, a link of some sort. They dropped a drone, it took off. I got the link so we could essentially just watch a live feed of what the drone was seeing, and that was it.
Do you know if that live feed was recorded?
I do not know, ma'am.
Did you record the while that was happening?
Nope.
Did you create a recording?
No, ma'am.
What is a Bearcat?
I know.
Bearcat's an armored vehicle used in SWAT operations.
And do you know what
They're talking about
what
his
role the
parents'
Bearcat?
house
Describe that vehicle again.
in Pennsylvania.
They're usually built on, I think it's like a Ford F-250 chassis. So it's a pickup cab essentially, but it's got a
Ma'am, can you describe the Bearcat more? How much time do you have? So it's built on a Ford F-250 chassis, and let me tell you how cool this shit is. Dude, SWAT has some cool shit. I love that he's like, how much would you like to know?
a large box compartment in the back, for lack of a better term. Usually has portholes on the sides. It's highly up armored to protect the occupants, being SWAT operators. And they usually use them as an approach vehicle. So they have
That's a
a
great question. Love to tell you.
covered location to deploy from.
Is it a like a retrofitted military
No,
piece of
ma'am.
machinery?
No, ma'am.
It's specifically a law enforcement piece of machinery.
It's Bearcat.
It sounds like it's really big.
I would
mean, F-250
depend on
chassis.
what you're comparing it to. I'd say it's no bigger than, if you were to have a pickup camper on the back of an F-250, something like that.
And what's your
Ma'am, you're in Idaho. Are you
understanding
gonna tell
of
me there
where
aren't big
that
trucks?
Bearcat was?
Because I imagine Idaho likes its big trucks as much as Tennessee likes its big trucks. Tennessee fucking loves its big trucks. So I'm I'm going to guess that there are bigger trucks on the road in Idaho than the Bearcat. Sounds really big. I mean, it's bigger than a Prius.
Was parked for the arrest.
I believe the Bearcat, if memory serves, drove up the driveway and just parked in front of the house.
I'm going to leave this at regular speed until we hear the details of the arrest because we haven't heard a lot of it yet.
I'm handing
And I'm
you
curious.
what's been marked
Ma'am,
as
no, go back to the arrest. What else
State's
happened?
Exhibit 5
No, tell me more about the drone footage. Ma'am.
to the motion to
Damn it.
suppress.
Go back.
And it was attached to 119 Lambston.
Oh, good. We're still at the house in Pennsylvania. Great. So this is the search warrant for the house in Pennsylvania, Kohberger's home. And we're talking about December 29th, 2022.
Right, this is marked with an exhibit sticker S5. Title of the document is Pennsylvania State Police.
The court just making the appellate record for himself.
Heading with essentially a letter directed to Detective Payne.
Detective Payne, can you explain what that letter is?
It's Corporal Payne.
That's a justification for reasoning for amending the original plan for knock and announce to a hasty knock and announce and quicker entry into the Kohberger home.
When did you receive that?
I believe this was recently. I don't remember what date.
When you say recently, was it received in response to prepare for today's suppression hearing?
I believe so.
Do you know why Mr. Lang didn't date the letter?
I have to ask him, ma'am.
Calls for speculation. Why did somebody else
And
do a
so
thing
in
or
that,
not do a thing?
correspondence,
Okay.
he explains that the knock and announce was shortened to announcing from the Bearcat with immediate forced entry.
Yes, ma'am.
What's the warrant say?
Were you present when Detective Gilbert Mirandized Mr. Kohberger at the station?
Gilbertson?
Gilbertson, sorry, yes.
Yes, ma'am.
And that took place after Mr. Kohberger was first seized in his home, right?
Correct.
That also took place after he was transported in the back of a police car to the station, right? You noted in your report that Detective Gilbertson had a recorder in his pocket at the time of the interview.
I believe so.
Were there any recordings that took place at the Kohberger home when entry was made into the house?
I do not know.
It would probably be
Where was
body
Mr.
cam
Kohberger's car parked at the
from the
time of his
SRT.
arrest?
It was in the garage.
Was it later seized pursuant to a search warrant from that garage?
Yes, ma'am.
And when you said that the iPad receipt was found in the car, is that the car that you're referring to?
Yes, ma'am.
Lyndon, you make a very good point.
That is all the questions that I have for you. Thank you.
Damn it! I want more information about what we got right up to the arrest and the Miranda and the rest.
Cross-examination.
We have just a moment, Your Honor.
And then nothing. Crystal in the chat said, I keep forgetting the point of all of this. The defense made all of their motions to suppress. They are seeking to suppress all of the search warrants. The search warrants are a link in the chain. If the search warrant is the link that breaks, then everything that came from the search warrant is also gone. So they are
The
having
state doesn't have any clarifications for this one.
All right, thank you. Sit down.
no cross. They are having
actually-
their suppression hearing.
If you don't mind, I actually have a question.
Of course.
The court's like, actually,
Testified that you didn't send the affidavits and support of search warrants with the warrants themselves to Google, Apple, et cetera. The persons that processed the evidence received, would they have knowledge of and access to the affidavit?
Absolutely, Your Honor.
Questions and follow up to that?
I do. How would people that are getting an email through a portal, Apple, Google, AT&T, how would they have access to the
My
affidavit?
question was the people that received the evidence,
Correct.
not the people who sent it.
Correct.
So in other words, the
You
police
misinterpreted the court.
team that reviewed the evidence, did they have access to it? Not.
The return.
Okay, I didn't hear you. You do
Just
have,
to clarify.
you do have a soft voice and I am losing my hearing. But so then based on that, how would those folks get access to the affidavit in support of the search warrant when they're reviewing materials?
Just so I'm understanding you, those folks, meaning the people who work for these companies, is that who you're referring to?
No.
No, I think that's not what the judge was
Correct. I
asking.
understand.
He was asking that once that evidence is returned and you
The judge asked such a clear question, and now that question is covered in mud.
log it, his question was, do they have access to the affidavit in support of search warrant?
Right.
And your answer to him was yes, absolutely.
Yeah.
How?
There were paper copies of it. It was no secret. It was shared freely amongst the investigative team.
Okay. But not each person reviewing, various people are reviewing these, the electronic data for the some 67 devices and third-party warrant returns, right?
Yes, ma'am.
And in terms of my question earlier, which was who, I was asking about Apple, who's reviewing that data? Your answer was, I don't know, right?
Yes, ma'am.
So if you don't know who's reviewing something, how would you know that they have access to
That's a good
search warrant
question.
affidavit?
Well, that's the beauty of having a collaborative team effort. If you share the information freely, it's not independent upon myself to provide that to them. Everybody has that information to reference.
Working document.
So is in the database that you're creating with this collective, I'll stop this, break this down.
I'll stop
My
this. No, you
understanding is
won't.
that the collective document is Exhibit A, correct?
Correct.
And then when you attach Exhibit A to a warrant with Exhibit A to a affidavit in support of a search warrant, you also add additional language depending on who that warrant is for, right?
Correct. Yes, ma'am.
So there are over 100 different search warrant affidavits in this case. And it's your testimony that everybody who would have access to doing review of data has access to go in and look at what exact search warrant affidavit was executed.
I believe so, yes.
I have no further questions.
Follow up.
Those last two were good questions.
All right, thank you, Detective.
So
Guys, I
she's
think we don't need to step away, but I do need a break to organize my documents
Just watching.
for the next witness, who will be Detective Mowery.
ma'am. Oh, to reorganize the ones you handed up and put them in order. Okay, that's fair. She was getting at, how do the people taking in the search warrant returns know that what was returned is what was asked for? That's essentially what she's getting to. We're going to zoom a little bit. We love our zoom room. Well, she puts things back in order after they'd been handed up to the stand. That's completely fair because it's the same documents.
Sworn, one of my staff took the opportunity to take a break. They'll be back in a second.
So we are going to the next witness for the defense. The defense is on their motions to suppress. So this is defense witness
I
2.
think it's fine if you just want to start with.
For this hearing.
If you're going to ask him his background, you can do that.
Good morning. Detective Mowery, could you please state your name and spell your last for the record?
My name is Lawrence Mowery, Mowery.
What's your current job?
I am a forensic detective with the Moscow Police Department.
And could you tell us about your background in law enforcement?
I have 14 years of law enforcement experience in the state of Idaho. I've been with the Moscow Police Department for the last 6 years in this current role.
Forensics are cool.
What is your role in this case?
I was, I guess, put in charge of, lead, I don't know. I was the one that was looking at and funneling the excessive amount of digital data and evidence that was coming through.
Have you taken on any other roles in this case? Have you had other duties?
If you're asking about serving warrants for digital evidence, then I've done that, yes.
I mean, he was in charge of the digital
Heard-
evidence.
Judge, am I?
Yeah, you're
sorry,
fine. Go ahead.
Okay. Do you agree that the Exhibit A that's been discussed was and attached to warrants, that was a group effort?
Yes,
Have you been a part of that group?
I was.
What
Again,
role did
Exhibit
you
A
have in
is
the
that
first
working doc.
AT&T warrant?
I don't recall specifically. I was there when it was being discussed.
She did drop that there were
Recall
over
that you served that warrant?
100 warrants. So to say, do you remember your role in this one AT&T warrant, and him say not specifically, does not shock me when over a couple of days they were probably doing 30 plus warrants. How did you do that? Well, I emailed it to somebody because there's a list of emails
I do.
for the law enforcement contact.
When you served that warrant, did you serve it with the search warrant, with the affidavit in support of search warrant attached?
No, ma'am.
Is it your practice to ever serve an affidavit in support of search warrant with the warrant?
No, ma'am.
Because they don't
You
need to.
co-located with Special Agent Nicholas Balance as well?
Yes, ma'am.
What was the distance that you had in proximity to him?
He sat in the same lab that I did.
And so was that a cubicle setting? Can you describe the setting?
It's a secured forensic lab. It has a door.
And then inside, is it open? Were you in separate offices?
It's a single room.
Single room. And so you were literally in the same room with Agent Balance.
Yes, ma'am.
And was that for the entire time that he was co-located there?
Yes, ma'am.
Were you aware of his ability to have access to AT&T records without a warrant?
We went to 1.25.
All right, I want to talk now about.
He didn't
the
answer. Hold on.
Were you aware of his ability to have access to AT&T records without a warrant?
No, ma'am.
Oh, he said no, ma'am. I was talking. I've got questions
Right,
about
I
that
want
too.
to talk now about the cell phone, also known as the USB. Do you recognize that? I should say, I'm so sorry because there are so many cell phones. Brian Kohberger's cell phone. I want to talk to you
The
about.
physical cell phone or the data from the cell phone?
We're going to talk about both of those.
Okay.
So for purposes of today's argument, we've called it cell phone / USB. How
Is
did
it
the
a
state come
BSUSB?
into possession of Brian's phone?
Obtained via the warrant in Pennsylvania.
Was a copy of that phone made prior to the search warrant being signed?
Which search
Copy
warrant?
of Brian's cell phone.
Again, I'm asking which search warrant. You're talking about the one from Pennsylvania or the one that we requested once the data returned?
I'm talking about when it was first seized. So it'd be the first.
The Pennsylvania one?
Right.
I do not know.
You're aware that a copy of the phone was made and put on a USB.
Yes.
And then a warrant was obtained to search the USB.
Yes, ma'am.
That's the second warrant.
Yes, ma'am.
Was the cell phone searched prior to the warrant for the USB?
The extraction was created before the warrant in Idaho was requested.
Was the extraction searched before the warrant was obtained in Idaho?
So the differences that they are talking about is the difference between when Bryan Kohberger's phone was seized versus when Bryan Kohberger's phone was imaged versus when Bryan Kohberger's phone was searched. So the seizure, the forensic extraction and forensic copy, and then the search, those can be different. A, those can be different warrants, but B, those can be different places in time. So having an arrest warrant for him and a warrant to search his person and a warrant to seize any electronics, different than the warrant to then search the things that were seized. So that's why they're talking about the different points in time. And it doesn't, with the facts that we have, it does not specifically matter that your phone being extracted after it's properly seized, being done before the warrant for it being searched, as long as it's not searched. Under your scars, your phone can be searched at a traffic stop. Not necessarily, it can't. And in many states, not without a warrant, especially if you have a passcode on it. So no, in a lot of jurisdictions, your phone cannot be searched pursuant to a traffic stop. That is not accurate. Also, always have a passcode on your phone.
And how do you know that?
I was the one that received the extraction.
The extraction, where was the extraction made?
Pennsylvania.
And who made that extraction?
I believe it was Special Agent Tanzola.
And how did Special Agent Tanzola get that extraction to you?
You'd have to ask him. I believe it was using a Cellbrite product.
You have to ask him.
So what about is the USB not a physical box of the extraction, or is it all digital?
What?
USB is just a storage device that the data would be placed onto.
So with the extraction and the USB, can you explain the process of the extraction being made and it getting to you and it getting put on a USB?
I mean, he didn't do it. So
Normally in a forensic environment, the device is extracted, that extraction, and then therefore be placed onto a different storage device for evidence storage or for sharing with other forensic investigators.
And so you said normally, but I'm asking you specifically to Bryan Kohberger's cell phone.
and he said specifically
It was placed on a
he
storage device.
didn't
by
do
SA
it.
Tanzola and provided to me.
And how did you get the storage device?
I believe it was brought back. I don't recall how it was given to it. It was still in the FBI packaging.
Do you have any personal knowledge of whether or not
Sir, how did the USB end up in your hand from Pennsylvania? Somebody gave it to me.
Special Agent Tanzola reviewed the data of the extraction before the search warrant in Idaho was obtained?
Gonna have to ask Tanzola.
Recall.
Okay.
Did I slow us down? Are we still at, oh no, we're still at 1.25. Damn it.
Judge, this is when you don't have yet either. This is Defendant's Exhibit A to cell phone. And it does have a sticker on it.
Do you have an extra copy of that?
Pardon?
Do you have an extra copy of that?
The ones, I handed two, right?
Yeah, and just going forward, I need 2 copies.
I will. I heard that message yesterday, Judge, and I apologize. Moving forward, I will make sure that there is that extra. I'm assuming you want it for your clerk. So,
My staff attorney,
yeah,
yes.
So the court said, just as a reminder, I need 2 copies, one for the court, one for the staff attorney. Being a staff attorney for judges is an interesting job and something I enjoyed doing.
For the
Though,
record, as I've been doing, this has been marked Defendant's Exhibit Number A with a date on the sticker of 11/14/24. The document on which the sticker is placed, first page is affidavit for search warrant. Directed to the Moscow Police Department Forensic Lab.
though I am a chatty Cathy, so the solitariness
How
of
did you
that
create
job was
the
not for me
affidavit in
long
support
term.
of the cell phone of the USB warrant?
How did I create it?
Yes.
So I'm not understanding. That's a vague question.
How did you go about drafting this? Is this a document that you had, that you filled in from, or did you start from scratch? How did you
I
come
don't
up?
remember the exact way that I did it, but it's not, this isn't very different from, say, an ICAC warrant that I would have had previous intentions to search the cyber tip information that would be already placed into evidence at the digital forensic lab.
So there's knowledge about what you're asking for and lists of things to get, what are you basing that knowledge on?
I would be basing this on information that I've done in previous cases, other warrants that I have served, and other warrants that I have viewed from other investigators throughout my time.
Can you turn to page 24?
Okay.
You see that page?
Yes, ma'am.
And is that a page entitled search warrant?
Yes, ma'am.
Looking at the first paragraph of that search warrant, is there any reference to search warrant affidavit in the warrant?
No, ma'am.
And is the date of the crime on the search warrant?
No, ma'am.
On page 25, can you turn there? There's a directive to search the premises. Do you see that?
Yes, ma'am.
What's the premises listed as?
155 South View in Moscow, Idaho, in the forensic lab. 155 South View, one word.
Does it say USB in that descriptor?
No, ma'am.
That's interesting.
Can you turn to page 28?
She's saying that the warrant says to search the crime lab, not to search
Is key computer
the
forensic lab?
USB. I would need to
Key
see
is
the
not
rest
a
of the
person,
warrant.
It's a thing. It unlocked the secure cubicle that the USB was placed into by myself so that it was secured. I had the key, and entrance was obtained by key in the computer forensic lab.
That makes sense now. I thought it was the name of a company, and I don't know why, but that makes sense.
She's like,
Key
ah,
Computer forensic lab.
I was confused.
Who was ultimately in charge of searching the USB drive?
The data was extracted, or not extracted, but reviewed by several different people.
Okay, who are those people?
I don't know all of them. Myself looked at some of the information, but not all.
Sir, who searched
And
it?
you said you don't remember all of them, but who else do you remember?
The information was also given to the FBI. The FBI had that information and they examined it.
The who?
Do you know who with the FBI?
No, I do not.
Can you turn to page 27?
Casey in the chat asked, why does it matter? Who searched the thing pursuant to the search warrant
Can you
does
look at
matter,
Page 6,
especially if there
or not
are
page 6, I'm sorry.
reports the
Number 6,
defense
line number 6.
doesn't
You see that?
have. If somebody
What does
searched
that
it,
say?
Copy of the warrant inventory sheet were left with the drive.
if somebody searched it without having the search warrant signed saying you can search it, there can be problems there. We don't have enough information, but who searched it? We need to know who searched the thing because they need to make a report. There should be chain of custody forms. So who searched it does matter because everybody can't just look at a thing. You need to have all of that documented. So yes, this part does matter. How much it matters is unknown because we don't have all of the information. We have very precise questioning here, and there is a world of information in addition to this that we do not know.
And that does not indicate that a copy of the search warrant affidavit was left with the drive. Is that right?
No, ma'am.
Okay, I want to talk now about Amazon. Did you swear to several warrants for Amazon?
I did.
Do you know specifically how many?
I do not recall how many.
Ma'am, I don't recall
How
how
were the
many
warrants
packages
served?
from Amazon arrived this week. I don't blame him.
How did you serve Amazon warrants?
I believe that Special Agent Michael Douglas assisted in service of those.
Sir, how did you serve the warrants? Well,
What training do you have in Amazon accounts and records?
Douglas did.
I do not have any training for Amazon specifically.
Sir, incorrect. The correct answer should be well. As a frequent user of Amazon, I am aware that it is a website where you can buy things and have them sent to you. I don't know if you need specific training on Amazon. All companies have some type of law enforcement contact, and you reach out to them and say, hey, we need information.
And I think you answered my next question, but there was a reference in the warrants to a special agent locating an Amazon account. Is that the Special Agent Douglas?
I don't recall who was that, who found that information.
How was an Amazon account located?
I don't know.
In your affidavit, where you've got language that talks about what Amazon holds and how it identifies and the list of items that can be collected, if you don't have any training in doing an Amazon warrant, how did you know that? To put that?
I was relying on the experts that have worked with or served the warrants to Amazon previously. I believe that information came from Special Agent Michael Douglas.
I can tell you how they probably found it, but that
In
would just
your-
be speculation.
In your affidavit, did you indicate that that was based on your knowledge or on someone else's knowledge?
I based it on mine because I spoke to Special Agent Michael Douglas about it.
Right, 'cause he told me.
Informed me that this was the information that we could request.
And so did he provide you with a kind of a mock-up affidavit to use so that you would know what language to include?
I don't remember if he gave me a mock-up, but obviously he would have helped me with the wording of it.
The wording of the warrants is pretty technical, right? All the list of items that is asked for.
Any electronic service provider usually has their special way of asking for things.
And so since you don't have training in Amazon, you relied on Special Agent Douglas for that?
Yes, ma'am.
And you're allowed to.
Okay, Google is the next one I want to talk to you about. What's your training about Google?
Again, I have no specific training to Google. I've served various email or warrants on Google for other means.
Is your experience with Google isolated to this case?
Ma'am, you just
You've
learn
done
by
Google
doing
once
is what he's
before.
saying.
Yes.
How did you get the form that you used for the Google warrant in this case?
The Google form, I probably relied on previous warrants that I've served.
Do you know how many warrants you obtained for Google in this case?
It's 3.
On January 3rd, that January 3rd, 2023, that warrant asked for Bryan Christopher 1994 at Gmail, 2 phone numbers, and an IMEI number. What's an IMEI?
International Mobile Equipment Identifier.
And how did you get that number to put in the January 3rd, 2023 Google warrant?
I do not recall.
Probably from the phone.
Okay.
But somebody would have had to have gotten it from the phone, and I'm sure he does not know which one. Witness said, why 3 warrants for Google? There could be a lot of reasons for 3 warrants or more. It could be different information came in later on different dates. It could be different warrants for different email addresses or potential accounts. So it could be a variety of reasons, but that's not uncommon that you would have multiple warrants. And sometimes you have follow-up warrants because the information that you get leads to other information, and then you need another warrant and you go from there. So it really just depends, but that's not uncomfortable. For all of you going, hey, that's what IMEI number stands for, or IMEI stands for, yes. Man, we were on 1.25.
Communications with Google.
No, I went too far.
Were you, in preparation for creating these warrants, were you having communications with Google?
Specifically about these warrants.
About being able to get the data via warrants?
I don't recall communicating with them specific to these warrants.
Okay, I'm going to hand you what's Defendant's Exhibit F to the Google Memorandum in Support.
No, I'm curious. Also, a lot of times, there will be a law enforcement line or liaison or representative at a company, and you can call and say, I need to find this type of information. Does your company have that type of information? We'll send a search warrant. They don't give you the information, but they can tell you
Recognize
broadly
that?
what
There's
type
an
of
email between
information
myself and a Francis from Google.
they have. Apparently Francis
Is
from
this
Google.
how you were communicating with Google via email?
I was communicating with Google for other, I'm not sure if this is the one for this specific warrant, I guess is where I'm getting at. There was question of what Google could provide. We served Google at one point with a warrant. They said it was, they couldn't do it because there'd be too much data. So they were trying to assist us in, well, basically not spending $100,000 of getting them data.
So to be clear, when I'm talking about the communications generally, I'm talking about your communications with Google about all the warrants. So was there email and telephone communications or just email?
I believe I spoke with their legal representation on the phone. I don't remember if there was other conversations.
Do you understand the difference between a personal account and a not personal account on Google?
I do not.
Well, there's reference to DeSales and DeSales helping from their end. Can you explain that?
I don't recall what that means.
Do you recognize what
College.
DeSales is in the course of this case?
It references an email address that was associated with the defendant.
And that email address associated with the defendant is a college that he attended, right?
Yes.
And so what was there communication with DeSales about them not wanting to produce records pursuant to a warrant because it was educational records protected by federal law?
I was part of a little bit of that. Detective Payne knew more about that conversation, but yes.
And so what I'm trying to understand is what was DeSales doing to help?
Man, why didn't you ask Detective Payne? If Detective Payne was having those conversations, he was just on the stand.
I believe DeSales was just waiting for a warrant. I don't recall completely.
And did you serve the Google warrants?
I believe I did.
I believe you said you did.
Yes.
And consistent with what you've said earlier, you did not include an affidavit in support of search warrant with
No,
that? Why did you choose the timeframe of January 1st, 2021 to December 30th, 2022?
I don't recall the specific reason why we went back to January 1. It was to include the time that we believe that the defendant had entered Washington to become a student nearby the crime scene and just prior to that.
But you know that he didn't come to Pullman, Washington until June of 2022, right?
Correct.
Did you review the Google warrant return
He said that's
emails?
not correct.
Yes.
Did you review? So you said you reviewed them. Are you the one who's in charge of evaluating those materials for this case, or is that designated to somebody else?
The materials came to myself, at which time it was disseminated to other investigators and the FBI as well.
Is
The
it fair
who?
to say that between warrant 1 and warrant 3, it's gone from 2 gigs to over 13 gigs of material?
It was substantial information.
And have you done anything to verify whether or not the materials produced are within the scope of the warrants?
I usually made sure that they were from that specific account when it's received, but I did not go into depth of the evaluation.
Let's talk, the final area is about the Apple
Okay.
warrant. What was your role in those warrants? In that warrant, sorry, not plural, singular.
I don't remember that specific one. I know I was involved in a lot of the Apple iCloud warrants.
What kind of
And
communications
Chad,
did you have with
his-
Apple to facilitate getting the
He
warrant?
is sitting to like the complete side of the
I don't
microphone.
recall prior to.
I'll hand you what's been marked as Defense Exhibit C to the Apple warrant. It does have a sticker on it. And it's not to the Apple warrant, it's to the memorandum in support.
Exhibit C attached to their memorandum dated, exhibit sticker dated 11/14/24. Appears to be a printout of some emails.
Tell me what's in the emails. What's in the emails? Somebody just handed the judge a note. Make it stop. What does the sticker mean? It's just the identification.
Have you reviewed those?
Yes, ma'am.
Can you, does that help refresh your recollection regarding what communications were occurring?
It appears that there was communication between Apple and the FBI.
And were you included in that?
I believe I was.
Okay. And did that include chats,
I believe the word chat means to chat, to talk.
like telephone talk or Zoom talk, or what was the method?
I believe it was telephonic.
So what kind of help were you getting from Apple, and what was the FBI getting from Apple?
I don't recall the conversation.
Oh, ma'am, I don't know
This
what the
was
FBI got.
Specific to the FBI's current investigation.
Right.
As I stated in my email there for the stalking investigation, I was merely just privy to their conversation.
Stalking investigation.
Have all of their materials related to that been turned over?
Who's there in that sentence? Counsel?
Pardon?
Who's there in that sentence?
Sorry, FBI.
I do not know. I wasn't, I don't know.
I have no further questions.
Okay. Well,
A few questions, Your Honor.
the prosecution's got a few
Let's stay here.
questions.
Just a few follow-up questions.
So this is technically
When
cross.
you received the evidence back from these various providers, did you have access to what we refer to as affidavit for search warrant and Exhibit A?
Yes.
Okay. And did you use that to determine the scope of what you would be searching for from those providers?
If I was to be doing the investigation, yes, I would have looked at those items.
And you testified that several investigators helped MPD in review of evidence back from providers.
Yes.
To your knowledge, did those investigators have access to the affidavit and the Exhibit A?
Yes.
I don't have anything further. Thank you.
You redirect.
No, Your Honor.
That's what the judge asked last time. She just asked it because the judge asked it last time. Okay.
I have no further witnesses.
All right, why don't we take a 10-minute recess and we will then pick up.
All right. They're going to take a recess. We're going to get to argument in this case. I'm going to zoom past the recess so we can see what their argument is. I'm going to just
Several of
recap
the warrant.
where we're at briefly as we get to argument after the break. The defense is arguing their motions to suppress, meaning they are arguing that there is an issue with the warrants in some way to try to suppress the evidence that that warrant sought and then that warrant turned over. We've heard specific questions about some of the affidavits. The full thrust of the motions are warrants to suppress or motions to suppress warrants from Amazon, Apple, Kohberger's apartment, the arrest warrant, the warrants to AT&T for the cell phone data, for the pen trap and trace data, for the Google accounts, for the search warrant of the person in Idaho, for the search warrant of the person in Pennsylvania, for the white Hyundai, and for the location in Pennsylvania. So all of those, and also the IgG DNA that they addressed yesterday. So they are going to be focusing on those warrants, all of them, in their arguments, saying to the court, the evidence obtained from these warrants should be suppressed because, and that's their argument. And the state is going to say the argument for keeping all of the warrants is because insert argument here. So let's see what their arguments are. Their kind of top line argument yesterday, and I think their top line argument will continue to be, Your Honor, they only got to this because of the IgG data. And if the IgG is thrown out, then, well, none of these warrants are sufficient because they don't have sufficient cause to tie Bryan Kohberger back to the search warrants. She asked quite a lot about, did you provide the search warrant and affidavit to these providers, Google, whoever. They said no. Right. Because you just send the search warrant to the company and say, company, you are commanded to give me, and then there's like a list. This shit. And it sounds like the first time Google came back and said, so what you've asked for is much, and we're not going to do all of that. So can we narrow this down? So we'll see the arguments today that are going to, I hope, focus beyond that DNA, because those arguments were yesterday, and we'll get into focusing on where they think the issues are with the warrants themselves, with the affidavits themselves, with the way that they were done. And again, it's not an issue with the warrant if more information is turned over by Google or Apple. That's not really the question here. The question is, did law enforcement follow the proper procedures for search and seizure? So let's continue.
Defense may proceed.
Into arguments. And then maybe we'll be done.
Judge,
One
I'm
can
going to
hope.
cover several of the warrants, and then Mr. Logston's going to cover 4. So I'll just wrap all of my argument
where
up
is he?
instead of getting up and down for
Wait, where is Mr. Longston? Where?
each one. My oral argument is not meant to rehash every point briefed or every argument briefed.
Well,
I'm
thanks.
giving you big picture comments based on the testimony, but I want to make it clear that we're not waiving any written argument.
You guys are saying he's in the second row. Thank you. I was like, where? He's normally at council table. To be fair, I'm going to put her at normal speed. And then if it gets slow, I'm going to have to just put it back to 1.25.
While I question Corporal Payne and Detective Mowery about some exhibits, but not all, it was not an indication that others are not important. I wanted to make important points, but not belabor. With IGG and Franks having been addressed yesterday, and the fact that the primary issues that I'm addressing have to do with general warrants, I'm not going to rehash those arguments, and I'm going to focus on the legal issues, beginning with the AT&T Warrant 1, Pin, Trap, and Trace, also known as AT&T 2, and the cell phone /USB drive. The Fourth Amendment requires particularity sufficient to prevent the exercise of discretion by an executing officer. The particularity requirements objective is that necessary searches should be as limited as possible. A search warrant must be particular enough so that as to what is taken, nothing is left to the discretion of the officer executing the warrant. The government cannot seize the haystack to look for a needle. And there is an undisputed privacy interest in cell phone data, including cellular site data pursuant to Carpenter. All 3 of these warrants were issued in December 23rd and early January 2023. The 2 AT&T warrants were issued on December 23rd, 2022, within an hour of each other. The first did have a temporal narrowing. AT&T 1 had November 12th, 12 a.m. to November 14th, 12 a.m. The warrant itself was extremely broad and did not incorporate the affidavit. In support of this actual failure to incorporate, the officers admitted that they did not incorporate in the search, but to the extent that the state is going to argue that when the warrant says upon offer and proof, that is the same as hereby incorporates an affidavit, I pointed out the language in certain search warrant affidavits to show you that they do know what it means to actually use the language herein is incorporated Exhibit A. And that same language is not used in a single search warrant affidavit. So the incorporation that would be a remedy for this issue potentially of particularity doesn't exist when the search warrant affidavit is not included. Even if for some reason you were to determine that there was English language meaning upon proof and oath is the same as hereby incorporated. The language in the search warrant affidavits themselves is extremely broad. The affidavit of return signed by Detective Payne's, this is on affidavit AT&T 1, says that the warrant was served by email, and as he indicated, it did not include the search warrant in support. The
I thought it
description
didn't
of the
include the
property in
affidavit in
Exhibit
support.
A to AT&T
It has to include the warrant.
described the property as just a phone number with no other description of the property, which indicates a lack of knowledge of what was actually seized and going to be searched. The second AT&T warrant and install pin trace was requested within 1 hour of the first warrant return at 3:50. The data from warrant 1 was analyzed such that by Special Agent Balance, such that Detective Payne was relying on Balance in his affidavit to support it by saying that the data that had been in their hands for less than an hour supported that the phone was possibly off going south on Pullman at 2:42 a.m. And there is just got to be a question for everybody of how does this massive amount of data get analyzed in an hour to create a second broader warrant?
Cell
The
site data.
warrant language in AT&T 2 pin trap trace is extremely broad, and the time frame goes from June 23 to 2020, June 23rd, 2022 to present. The crime of homicide was stated, but the date of the crime was not stated. There was no other specificity in the actual warrant. The warrant asked for extensive data, location data, timing reports, cell tower information, and installation of a pin, trap, and trace, among other many things. And when the warrant was served, a check the box form was included as a cover sheet to AT&T. Turning to the cell phone is first seized when Bryan is arrested. It's copied by Special Agent Tanzola without a warrant, and then that USB drive makes its way to Idaho in an unclear fashion. It sounds to me like it came back with Corporal Payne, who was there for the arrest.
I mean, you didn't ask him.
And when that warrant is obtained for that USB drive, it's put in a safe with just a copy of the warrant that has no date of the crime, and there's nothing particularized about what is to be searched. This creates a general warrant with 100% total discretion and nothing to limit the search. And if you believe that access within a database by somebody unidentified other than Mowery, who's going to evaluate that warrant, that they're going to look and pull that finalized search warrant from the database that everybody supposedly has access to, looking at that search warrant affidavit, there's full discretion to search the USB drive. There's no limitations and no efforts taken to address that. Turning now to Google and Apple. A very instructive case on Google and Apple is the Idaho Pilling case, which is 721 FSUP 3D 1113 2024. It's almost totally on point with this case. It is a federal case out of the District of Idaho, but it really couldn't be more instructive in terms of looking at these issues with Google and Apple. There's without a doubt a recognized protected interest of private information in Google and Apple records. Google contained private emails, schoolwork, research, among things, and Apple was essentially a copy of a phone and iPad that went all the way back to 2016. 2018 was an indication of when an iPad was purchased, but 2016, according to the documents that were prepared, were when it was identified that an Apple account was first created. Carpenter applies, and to the extent that there may be third-party materials like search history not related or documented, nothing was done to do any sort of segregation with regard to Apple or Google. For the Google warrant, by January 3rd, 2023, law enforcement knew many details that they could have used to narrow those
So
warrants.
lacks specificity
They
for
knew
all
that
of these
Bryan hadn't
arguments.
been in Pullman until June of 2022. They knew the names of the deceased, which were not included as language in the Google warrant. They knew the fraternities and sororities. They knew the students' names who had also been at the house on the morning of November 13th, 2022. They knew the date of the crime, of course. They knew emails. They knew social media accounts and names. They knew where students worked. They knew their friends. They knew their phone numbers. None of that was included in the Google warrant to help limit and make that something other than a general warrant. There's no language incorporating these search warrant affidavits, making these broad, sweeping categories, making the productions bigger and bigger. In Google, it went from 2 gigabytes to 13 gigabytes by the third production. And it appears that it's really unclear to these detectives that have taken a huge role in this case, who's evaluating what data and to what extent and what is being produced by it and what is within the scope of what is in an already broad warrant. For Apple, we are missing some sort of legal process that the state just hasn't filled the gap on, and these witnesses don't fill the gap on. We don't know what the legal process is that is referenced between the first request for a preservation in December 21st, all the way until August, when there is a production on a warrant. The steps that have been taken in between to get the information to put into the warrant are completely unclear.
When
And
was
to
the
the
warrant
extent
sent?
that these officers who swore to the contents of affidavits now have no memory of what that is, that's invalidating of those warrants. As for
Well, there must have been a
the
warrant if there's a return on the
arrest
warrant. When
and
was
the
the warrant?
car and the
She's saying they don't
apartment,
know.
what I will close by saying on those, because it's not an issue of general warrant or a discussion of particularity. Those are more reliant on the issues associated with IGG and Franks.
Yes, they are. They attacked the different warrants in different ways. And she's saying, look, the warrants from
And with
Pennsylvania
that,
are
I'd
solely
ask
being argued
that you find
because of the
that
IgG
the
DNA.
warrants that I've just discussed are general warrants, not particular warrants, and they should be suppressed.
All right, we'll hear from the state.
Do you want to respond to that, or do you want to have the defense argue the additional warrant issues and then address them all?
I'll take your lead, but I'm happy to just to piecemeal this, and I can address just those.
The court's like, what are we doing? All right, this is the state's response with regard to those
I can
suppression
make this
motions.
Pretty simple for the court. We don't have to go down the rabbit trail that the defendant would like you to go down. The search warrants
Is that a pink necklace? I like it.
regarding the particularity requirement. And this group that we're talking about is Apple, AT&T, there was a first and a second, Kohberger's phone, and then Google. All of these warrants were not general warrants. They were all sufficiently particular. They were specific to the type, each one of them listed that they were specific to the type of crime, the location, and all but one of them had temporal limitations. And for the one that didn't, that would be the cell phone warrant. That warrant was more particularized in the types of data that officers were allowed to search for. It's the state's positions, these were not general warrants, and your court can determine that just by looking at the face of the warrant. If you have any questions.
Thank you.
the state submits, you should deny their motions to suppress for these issues.
All right, that's the state's argument. So where we're at on those warrants, largely the tech warrants, and again, I will link down below when I covered the defense filings. Most of the defense filing arguments are that these warrants are too broad. They are not particularized. They allow for too much discretion of picky, choosy, guessy, whatever you kind of want. The state is saying these warrants are tailored to the information in the case. They are not overbroad. They are specific enough here. And that is why the court should deny these motions to suppress. There's a couple questions from the chat that I'm going to grab real quick before we resume with court. Aurora's window said, is it common to question warrants before trial? I don't know if I've done a case with warrants where there has not been some sort of motion regarding the warrants. I really don't know if I've ever had a case where it doesn't come up in some way. So is it common? Yes, it is one of the most common parts of criminal practice when warrants are involved. Now, there are cases, of course, where warrants aren't involved, but yes, that is incredibly common. Andrea Payne Connolly said, does suppress in her context mean disregard all findings from the warrant or limit evidence presented in court to a specific window? This is a great question, and it means if the warrant is invalid, anything turned over from the warrant can also be invalid. There are exceptions to that, but that is what they are asking for generally. So if the warrant to Apple is bad, then anything turned over from Apple should not be turned over. Of course, there will be some arguments about inevitable discovery and what can still come in. So there are things down the road we will have to talk about, but we will see. And then Osk asked, do you think the Sean Combs motion hearings will come about? Yes. Will they be public? Yes. Will they be televised? No, because federal court. They will not. They will not. Just because said if a warrant was that bad, wouldn't Google or Apple likely have their lawyers look at it first? They have a whole internal process with their law enforcement response where they evaluate warrants. But generally, the check on warrants is if it was signed off by a judge. Warrants are different than subpoenas. Subpoenas might be evaluated a bit more critically because it is not as formal as a process to sign off on a subpoena versus signing off on a warrant. They're both asking a company to turn over information, but the warrant's been evaluated differently and signed off by the judge. So let us continue. Mr. Longston.
Your Honor, I was asked to argue.
Your Honor, that chair over there sucks. So I was sitting in the back and it confused Emily greatly. But let's continue.
The motion regarding the raid on my client's parents' home.
Sir, I like Longston's legal writing. I appreciate his advocacy as an attorney. I just want to know if we're going to get to the Magna Carta or some other form of public policy. I just want to know. I just want to know. I just want to know. Are we going to get there, Mr. Longston? He always entertains me, and he is consistent to a fault.
Home, search of his person here in Idaho, as well as
Back to the defense.
in Pennsylvania, as well as and the Amazon warrant. I think for the most part, I'll just rely on the briefing. I just want to clear up a couple of things. One of the areas that was covered in the Pennsylvania home raid was that the state had to have a valid warrant in order to enter the home. I think in the briefing, it gets a little confusing, but the point was not that Mr. Kohberger couldn't have been arrested as he was walking down the street via the usual channels in which that could have occurred. The point was that they had to have a valid warrant in order to get into the home. The only warrant that they have is the one that we're challenging and via the Franks motion. And so that was the purpose of that argument. The other issue in terms of choice of law, it sounds like the state's kind of accepting that Idaho Constitution should apply. We set out a few different reasons why that should be the case.
Yeah, he
Doesn't
is
seem like
quiet.
there's a big argument going on there. So
There we go.
unless the court has questions about it, I'll leave that alone.
Is that better? for
And
him?
then the other issue that I wanted to touch on is the right of privacy in the information that we have in our Amazon goings about why should the state have to have a warrant for that. I thought we set it out pretty well in the briefing, but I think, the big concept and takeaway here is in Carpenter and Riley, the United States Supreme Court starts doing something different. And I think what the court is starting to recognize is that to a great extent, the United States has become a sort of panopticon. That is, the concept of the panopticon is you have a prison in which you only need a small number of guards because you have a very
A panopticon? Are we going to like Dostoevsky? Like we've gone full crime and punishment, haven't we, sir? We are. We're going full crime and punishment. I like Mr. Longston. He is consistent. He is going to go there. Yes, it's a feminine phenomenon that I am backing up. I want to hear everything he has to say. All right, Mr. Longston, give it to us. Let's go.
is that to a great extent, the United States has become a sort of panopticon. That is, the concept of the panopticon is you have a prison in which you only need a small number of guards because you have a very heavy-duty surveillance system. In the United States, we have via our phones, via the internet, much of what we do is now surveilled and very easily accessible. And so the fact that we have the third-party doctrine made
Mr. Longston, just hear me out. Hear me out, sir. Like, I'm going to need CLE credits at some point. You're going to need CLE credits at some point. Can we just like grab a whiskey and have this conversation? Can we talk about digital ID? Can we talk about track? I am ready. I want to have all of the conversations, the theoretical conversations about where the blend is between law, surveillance, private companies, the amount of information you give to Amazon. Can the law just get it because technically you don't have a reasonable expectation of privacy, because we all know that Amazon is tracking us across all of the things. And if I have a conversation with Judge Abby about a certain type of blanket, all of a sudden I'm getting nothing but advertisements for it on Instagram. Right. This is a whiskey thoughts and like a big leather chair and a room with dark green walls conversation.
sense when it was being adopted back in the 70s and the 60s. It stops making sense once all of this information is easily accessible in the way that it is. And so our point is that the judiciary has to have a role in this. There has to be a judge between us and the executive. Otherwise,
Society has rules.
we're essentially allowing the executive to know everything about us all the time. And so the state makes the point that similar to the one that Professor Kerr made about going and getting bank materials. Once those were things that could be done simply and efficiently via these records, the person didn't have to go out and get the cash. The state argues in this case,
Yeah.
because of Amazon, Mr. Kohberger didn't have to go someplace to purchase items.
Right. You don't have to leave
All
your
of that
house.
would have been out in public. He's doing it on his computer. And so why should that make it private?
I liked this
And
argument.
the reason why that has to become private, Your Honor, is because of the vast amount of information that is.
I'm going to back this up and tell you what that argument was in the filings, because we covered this back in, I think, November. But here was the argument in the case law that he was pulling from, which is that when does this become private life versus public life? Saying that in the past, you would have to physically go into the bank. Somebody could see you. You were leaving your home. You were going to somewhere where you don't have an expectation of privacy out in the public. And so doing those things and conducting the everyday essentials of life required you to be out and interact in public life in that way. The argument is now, our private life and our public life has changed. And so you can do things in the privacy of your home where the case law establishes that you have a reasonable expectation of privacy in your own home, but you can do things in your own home that used to be part of public life. You can grocery shop. You can have Green Chef delivered. You can use your NordVPN. Emily, are you just shouting out sponsors? Yes. You can play Midas merch all day long. You can have the spicy books you want to read delivered instead of going to pick them up at a Target because the lines are too long. You can chat, you're right, you can go to the doctor. You can have prescriptions sent to your door. There are a lot of aspects of our lives that used to be out in public where you would have to leave and could be observed. You know, somebody could see you walking down the street going to the bank because there's no ATM because, you know, we don't love them things because then you lose connection with the customer, right? So you can now do these things privately. So this is not necessarily a today argument for Mr. Longston. This is a down the road argument for Mr. Longston. If Kohberger is convicted in this case, it is still a capital case. He could theoretically be in prison for a substantial amount of time. And if he is sentenced to death, then the appeals are going to be quite long. So if the law changes in the next 15 years with these questions about where is the expectation of privacy and does digitally transmitting that information to a third-party company, is that similar to getting out of your house and going into the grocery store? Is that just the digital version of leaving your home? You're leaving, we're all going to end up, you know, living in like in the cloud at some point, but is that the cloud version of leaving your house? And where are these analogies between if you go to the bank in person versus if you transmit that data from your IP address? So some of these arguments are down the road arguments in case the law changes, because the law is catching up to how modern life is changing and how we carry things out and what that changes for reasonable expectation of privacy. These are very good conversations for law review articles and for legal learning, and the courts have to catch up. But if the courts catch up down the road, this could benefit their client down the road. So, that is how we have gotten all the way to, in the past, you would be observed doing these things and you don't have an expectation of privacy. And now you do. So we'll see if the argument is now you have an expectation of privacy, or you know that there's a digital trail. Therefore, you transmitting that information means you don't have a reasonable expectation of privacy. So these are the larger conversations that the law still has to have in how we move forward with how much information we choose to put out there versus not choosing to put out there. So that's hopefully helps with what the heart of his argument is. He put all of this in the extensive briefing they did on this case, but that is what he is arguing.
Because of Amazon, Mr. Kohberger didn't have to go someplace to purchase items. All of that would have been out in public. He's doing it on his computer. And so why should that make it private? And the reason why that has to become private, Your Honor, is because of the vast amount of information that is now so easily accessible to the government. If we don't require a warrant, we essentially put all of ourselves at hazard of being snooped on at any time.
Of being snooped,
And
I want to
so,
be of being snoop dogged? No. Snooped on. Snooped on. But they did get a warrant in this case, though, Mr. Longston. They did. Also, I know my Amazon driver by first name. So there's no privacy there. Like, we all know each other.
Government. If we don't require a warrant, we essentially put all of ourselves at hazard of being snooped on at any time. And so I also just want to just briefly bring up, I think yesterday the court had talked about privacy rights with the IgG databases. And I certainly want to make sure that we are preserving that argument. We included it in the briefing. We do believe that
Angie, yes.
Americans have a privacy interest in the genetics they share with other people and that other people then place within these databases. So that is not something that we intended to abandon in any way yesterday. If the court has no other questions for me, I would rely on the briefing.
Thank you.
Thank you.
Chat, you guys are having such an interesting conversation. I love it. And I love the point that was made by Adina saying, but you could choose to go to the store then. So if you choose to not engage in that digital commerce, then you could choose to engage in that commerce in a more physical way. And then you end up back in the example of walking into a bank. Great conversation. Law nerds, you guys are fantastic. Chat is bae, chat is wise, chat is smart. And these are interesting questions. Will it change much in this case at this point? Maybe not. But are they good questions to be asking? Yes, they are.
Your Honor, I'd like to address just the third party doctrine, and then I'd like to turn it over to Mr. Thompson to address the other motions to suppress.
Now back to the prosecution.
And the case that we're talking about is the Amazon records, and that's what has to do with the third party doctrine. And the U.S. Supreme Court case State v. Miller is the controlling case here. And Idaho courts, as explored in my briefing, apply Miller. And there's
Most
no
courts
reason
do.
for this court to diverge from that Fourth Amendment analysis. The documents are Amazon's business records. They detail transaction history. Business records are most akin to bank records, which is allowed. Applying the court's reasoning from Miller, again, these documents are business records of Amazon. They're not the defendant's private papers. Amazon is a party to those transactions. They have a substantial stake in these records. And the defendant took the risk when he revealed his affairs that this information would be conveyed by Amazon to third parties, including the government.
Right. You could have gone to the store with cash and a hat and purchased something.
It's the state's position, and it should be the position of this court. The defendant does not have a Fourth Amendment privacy interest in Amazon's business records. Thank you, Your Honor.
Right. You can go to the store with cash. I mean, if stores still allow cash, you can go to the store with cash and buy a thing to have some more anonymity than buying it on Amazon. They're fighting over the Amazon records a lot.
I'm going to address, I guess, the remaining warrants or the questions raised by the defense about the remaining warrants. I'd like to start first with the warrants for the residents in Pennsylvania. That expands into Mr. Kohberger's person under the Pennsylvania search warrants for his person, for his car, which was in Pennsylvania. And then the defense also raises questions about statements made by Mr. Kohberger to law enforcement. First, as to 119 Lambston itself, one of the first things the defendant offers to the court is claims that there was no local warrant, valid local warrant, and that simply isn't true. As the record clearly demonstrates, there were 3 valid local warrants, Pennsylvania warrants, for the residence, for the defendant's person, and for his car. The defendant then asserts, and I appreciate Mr. Logston's clarifications, but essentially the defendant asserts that there needs to be a separate special warrant in order for Pennsylvania to take the defendant into custody as a fugitive from Idaho on our charges. And as we cited in our briefing on this, the statutes in Pennsylvania and Idaho are virtually the same, and they clearly contemplate that a felony fugitive can be taken into custody without a fugitive warrant under the circumstances that exist in this particular case. Now, if the issue is the law enforcement presence or access to the defendant inside his parents' residence, we would submit that's already addressed because the Pennsylvania State Police had a valid search warrant for the premises,
residence,
for the defendant's person, and for his car. So they had lawful process to be where they were, where they found the defendant and took him into custody.
Right. If you can search
as
the house for a
fugitive.
person, you can go into the house and
The knock and
the
announce,
person.
there was discussion earlier today and the explanation of what happened with the dynamics of the knock and announce. That's detailed in Sergeant Lang's statement, which is now has a current cover affidavit to it filed with the court. That's S5. I'm not going to publicly go through all the factors unless the court wishes me to, because they are quite incriminating as far as the applicable factors that would justify either an abbreviated knock and announce or, frankly, elimination of knock and announce entirely. And from what we have before the court now, it's clear that Pennsylvania's police were operating in a dynamic sense, reacting to real-time information that was coming in. That's all documented in the various reports and log sheets that have been submitted with our pleadings, which are not particularly lengthy in nature. Finally, as to the defendant's statements, I think the key notion here on any statements the defendant made, and frankly, he really didn't make much in the way of incriminating statements, is there was never any interrogation. He was Mirandized
talking.
eventually, but even the prior conversations that occurred with Pennsylvania law enforcement, there was never interrogation. And so Miranda is not implicated, and so there's no issue on the statements themselves. As to his car and his person, as I've already mentioned, there were valid specific Pennsylvania search warrants for each of those. So those are presumed to be lawful. There's been no substantive attack on those. There is a motion to suppress regarding, and I'll use the air quotes, arrest warrant. And frankly, I have yet to be able to figure out what arrest warrant is being referred to. But again, all the actions in
Your Honor, they
Pennsylvania
didn't do their
were taken
assignment.
pursuant to valid warrants, search warrants from the Pennsylvania courts and the applicable fugitive arrest statutes. And so we don't see that there's any issue before the court there. The defense also raised the issue of a search warrant for the defendant's person in a separate motion, which appears to be the search warrant for the defendant's person here in Idaho when he was returned to Idaho. And as the search warrant and the affidavit for the search warrant show, which were attached to our reply, there was a valid search warrant for that. I think any issues to be argued beyond that relate to the IGG and Franks that are already pending with the court. As far as the defendant's, the search of the defendant's apartment in Washington, for whatever reason, the defendant did not include all the documentation with their particular motion to suppress, but we provided that in our response that there was the Washington search warrant. There was
But they
also
didn't
an
argue it at
amendment to
all.
the Washington search warrant. The Washington search warrants, the applications included all the information, the Exhibit A information from the state, and then the WSU Police Department added their additional state of Washington specific information. There's nothing to question the validity of that warrant on its face. So, Your Honor, unless the court has questions, I don't have anything further to offer in the way of argument.
The court's like, yeah, I'm good. His face is giving, I'm okay.
Fox, any rebuttal?
If you're okay, I'm okay.
I think I just rely again on the briefing for the most part. In terms of the knock and announce, I think the totality of the circumstances of this particular raid are something that the court has to be cognizant of. If Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is that they were able to
Telling me
do.
facts about which I have no idea. And so it's not going to be helpful to compare it to
Well,
whoever Mr. Roof is.
I guess the point is that in this particular case, the state manufactured the exigencies if they had them at all. The reality is, as they explained in their own affidavit, they're essentially watching Mr. Kohberger as he moves around his house via snipers. I mean, they were quite safe, and there was simply no reason to bash the doors in momentarily after yelling from their Bearcat.
There's two issues. There's officer safety. There's also destruction of evidence concerns.
In the cases that we cited, Judge, when the claim has been that there's evidence being destroyed, the evidence, what's known to the officers is something along the lines of They hear somebody running away after they announce themselves. It's not typical that the police simply don't knock and announce at all in those cases. They usually give the person the opportunity to surrender, but it's not a particularly long one. And in this case, they don't do that at all. And the only thing they knew is that he's walking around from room
It
to
says
room
they
and that he
announced.
has some kitchen gloves on. And I don't think that equates necessarily to the destruction of,
That he's walking around the
That's
house
not
with
all
gloves
of it,
on?
But I won't go into the detail in order to preserve,
Sealed record.
so as that we don't go into those issues.
Yep.
thank you, Judge.
The
But
judge
beyond
was
that,
like,
we'll rely on the briefing.
Shit's
Thank you.
sealed for a reason. We're not going any further, Mr. Longston. Shit's sealed.
Okay. I'll take the motions to suppress under advisement and issue ruling forthwith. The next issue is the state's motion to compel regarding the defendant's expert disclosures.
All right, we're moving on to
Sorry, Your Honor,
discovery
the
motions.
Defendant's motion to compel the state.
Did I say the state's motion to?
He did say the state's motion. We're moving on to the defendant's motion regarding discovery. So we are now done with all of the suppression motions and we are moving on to other motions. So the court will issue a written ruling down the road. And now we are moving on to motions to compel.
To compel the defendant's motion to compel regarding the state's expert's disclosures.
We did file ours yesterday, so their motion may be coming.
Well, I would be impressed if they had filed something already on that, given they were just
Here all day
served
yesterday.
yesterday afternoon. So
They were. Thank you. Your Honor, we are here on our motion to compel, asking that the court remedy what the state has done with their expert disclosures. We rely on Idaho Criminal Rule 16 and the court's order setting out what we should do and when we should do it in this case.
let me ask a question from a framework standpoint. I don't know what these folks are going to testify to at trial specifically as it relates to what they've disclosed. The way expert disclosure issues usually works, I don't tell a party what you have to specifically disclose about your experts. You disclose about what you think you need to disclose. If you haven't disclosed it consistent with the rule and you try to offer it, there's a good chance it may not come into evidence.
A very good chance it won't come into evidence.
That's the general framework. So I'm a little,
Court's like, why are we here? Counsel,
I
what's the
guess,
issue?
concerned about what appears to be you asking me to tell them what to say in their disclosures.
The court brings up a really, really good point. And I think it's a remedy the court has and one that we would hope and ask the court to issue in this case. I think when we filed the motion, Your Honor, we had a couple of disclosures that could appear to be disclosures with wiggle words in them.
Yeah, wiggle words are not going to save the lack of disclosure. I'll let the state know that right now. The fact that you say, well, he could talk about anything else, doesn't mean he's going to get to talk about anything else.
In an abundance of caution, we were worried about those words. I appreciate what the court's saying, and I'm going to make this really short. The lists are problematic for us. There are
Wiggle, 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 wiggle.
4 or 5 experts with lists. I understand what the court said. I like what the
They
court
also have
said.
reports that they reference.
What?
Lab people do have reports. I understand those are their opinions.
They turned over reports? There is a difference between an expert disclosure that says our expert is this, and they're going to talk about stuff. That's not a specific expert disclosure. But our expert is this, they're going to talk about these things and anything that flows from that, which might include rebuttal. And then here's their report is different because the report outlines what they're going to say.
Opinions. When we're talking about, and I'm going to specifically talk to you about their disclosure number 7. It's an FBI agent, Douglas. There's a list of financial records that he collected and looked at. Other than that those records exist, there's not a report telling me what they mean to him at all. If he's limited to say, I collected these records, this is what we have.
My understanding, the state can correct me, is what I understand
I
from
mean,
the
he can
briefing is
evaluate the records.
respect to that. And I think that's the Amazon documents, correct?
Those were some of those documents, Your Honor. There are a lot of others.
Was his expertise was in extracting or reviewing the information, and how those were sort of obtained electronically, and then simply guiding through, well, this is a transaction on this date that does this, which is not necessarily expert testimony, it's simply testimony.
No, but I believe it's a different expert that they have to do that does not have a report.
But is that expert testimony? That, let's just say, Mr. Kohberger on X date purchased a television. If for some reason that were to be
Relevant.
important, and that this transaction demonstrates that this is Mr. Kohberger's account, this is Mr. Kohberger's credit card, and this is the purchase on Amazon.
And it's a television.
And that was delivered to this address associated with Mr. Kohberger.
Those are factual issues, Your Honor. It's when we get to what do they mean? Or
That
I
means there
put
was a
these
television?
things together and I've made this picture out of something. That when we get to opinion, I appreciate what the court's saying. It sounds to me like lists don't do it if you want to interpret a record. That's what we hope to hear. That's what I wanted to accomplish today.
Well, I think it's pretty clear. You cannot simply say an expert's going to talk about topic A, topic B, topic C, and then be able to give a host of opinions that fall within those
You have to
topics.
disclose the opinions.
The requirement is to list what their opinions are and what they relied on to give those opinions. It's different than the civil rule. I don't think they have to give as much detail as the civil rule requires, but they have to at least give what the opinions are, and I believe what they reviewed, as I recall the rule off the top of my head.
I believe the court's about right. There may be another term or two in the rule that's specific, but I hear the court loud and clear. I'll point out one last thing, and
It sounds to me like they've
stop
done that
because I think I
then.
understand how the court interprets these issues and these rules. When you look at page 9 of the state's objection to our motion, and in the second to last paragraph, they tell you that they will continue to supplement their expert responses based on later discovery or whatever they decide to use. That whatever they decide to use has me worried. So I wanted to bring that up. I appreciate the court saying the court's going to apply the court rules and the discovery rules and follow the case law, and that's all we want. Thank you.
Okay.
So that I'm clear, as the state's approaching to talk about this, in terms of supplementation, it's allowed. It needs to be seasonable, which means it has to be not just whole cloth new experts, for example, without good cause showing me why that's necessary. It needs to be
Right.
seasonable in the sense of the timing of it based upon when the information was received, when it was determined it was necessary to supplement. And then obviously we'll look at that in relation to what may prejudice the other side in terms of the timing of it.
Certainly, I understand that. Their discovery deadline has come and gone. If something brand new happens, that would be a different
Right,
issue.
but you just turned over
would
your
assume we would
experts
deal
and they
with
might
that
have
then.
responsive experts.
It's when I read whatever
Right.
we decide to use, that's very, very broad. That's it. Thank you.
Okay.
I can keep this pretty short. I don't think that there's really much in dispute at this point. State's position, we've complied through our expert disclosures with Criminal Rule 16b7, as well as your court's scheduling order. State understands the framework that you've outlined. We were under the same impression, and I don't think that there's anything else in dispute.
Yeah, so let me give you a word of caution. Sometimes there's dissonance between what an expert thinks that they're going to talk about and what the lawyer understands from that expert and the lawyer submits these disclosures. And I think it's really important that you be on the same page if you don't have a specific written report from the expert about what it is they're going to talk about, and make sure that you have supplemented and that you have provided a listing of the opinions that are going to be provided and whatever else is required under the rule in terms of what that's based on. And I would encourage both sides to over disclose those opinions in caution rather than under disclose. Because two things.
Yep.
One, you may find yourself in a bad position.
Warning, counsel. Warning, warning, warning. If you do not disclose your expert opinions, they're not going to be making those opinions in front of the jury. So if the expert seems to want to make an opinion or a thought based on something, you're going to need to tell the defense that that's what that is. Specifically, this, when we got into the entirety of the hearing in Massachusetts with regard to Dr. Russell and Dr. Russell's opinions, there was lots of discussion at that hearing about, okay, well, you didn't submit a report. And then at the first trial, you said your opinions were this. And now you're saying the opinions are this. The court wants it to be bullet pointed. If using Dr. Russell in Massachusetts as an example, if that's the example, Dr. Russell would need bullet points of, it is my opinion that the injuries on victim John O'Keefe came from a dog. It is further my opinion that those were multiple injuries indicating a dog attack. It is further my opinion that based on the location of the injuries, the arm was in a position with the elbow facing out, raised, and that's why the grouping of injuries looks the way they do. It is further my opinion that those injuries are from a canine/dog and not from a vehicle. And then what those opinions are based on. Opinion, 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 and based. And he's saying, look, I'm going to say some shit is not an opinion. That is not sufficient disclosure. So he's just saying, you're going to need to list it out. And if you don't, you're not going to bring it in. And the court will often give the defense a bit of wiggle room on this and give defense experts a bit of wiggle room on this. And the state knows this. The defense may get a little bit more leeway on this. The state's not going to get any leeway on this. They're just not. And they know that.
In terms of what that's based on. And I would encourage both sides to over disclose
Amazon package.
those opinions in caution rather than under disclose. Because two things. One, you may find yourself in a bad position if you're not allowed to go into an opinion you felt you were going to be allowed to go to because it's not disclosed. And two, I don't want to spend half our day at trial with me saying, where's that disclosed at? And then chasing the jury out while you dig through your thousands of pages trying to find where that is. And so the more exhaustive your disclosures,
Y'all get it together.
the less likely it is it's going to draw that objection, and the less time that we're going to waste at trial trying to find where you disclose that. And so I think sometimes, and I'm not saying you did that in this case, I think sometimes lawyers view this expert disclosure requirement as sort of tedious work that they need to get done in order to comply with the timeline, a requirement of the court, and then they sort of move on from it and forget about it. It's a dangerous tact to take. It is, for the case, one of the most important things that you can do is to understand what the person is going to testify to and give a disclosure of what they're going to testify to, what those opinions are, and to be looking at that as you're thinking about their testimony, as you should be doing certainly now, even though it's months away from trial,
I mean,
on a continuing basis.
it's going to be here fast.
So I would really stress the importance of that in a case, particularly of this import.
Do more,
Um,
not less.
You know, and so don't feel like your job is done at this point, because I would suggest to you it's not. That you may consider needing to do some cleaning up and making sure things are more fulsome in the scope of those disclosures and what you're doing. The other thing, you know, I think you tried to do to a degree is you thought, well, we think this is fact testimony, but, you know, in an abundance of caution, we're going to put it in an expert disclosure. Well, if you're going to put it in an expert disclosure, because in an abundance of caution, it could be viewed that way, I suggest you treat it that way
With opinions.
in terms of what you give.
10-4, sir.
Thank you.
Go sit down. That's what the
And
defense
that goes to
wanted.
both sides. I haven't read your disclosures yet, so I don't know, you know.
That's
where
what the
that stands,
defense
but
wanted the court to
certainly,
do.
Goes to both sides. And I know that also, you know, the rules are different as to what the defense has to disclose necessarily and what the state does to some degree. And so I appreciate it.
Yeah, that's what he wanted.
Well, I
That's
think the
what-
court will,
That's what the defense wanted. Hey, Your Honor, we think that the state's disclosures are a bit bare bones. Could you help us out? And the judge went, state, if you're going to put shit in an expert disclosure, put the opinions in there. Do not hold back a more fulsome, which we love, a more fulsome exploration of what your experts are going to say. And then, state, I need you to have a list of what date you sent that over, what you said. I need you to put a tab on it, a sticky note. I need it to be in your binder. I need you to know where that shit is, because it's going to come up at trial. And I need you to have your finger on the button of, yes, Your Honor, this expert was disclosed to the defense on this day in this email, and the opinions are going to be this, 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 and that. And then sit the fuck down. The judge is like, are we done now, Miss Taylor? Are we done now, Miss Taylor? I told the state, I've given them ample warning. Now what?
anticipate that there's a rather large filing that contain a lot of actual reports. Your Honor, listening to the court's comments and understanding where we were a moment ago when we spoke, I feel like I must go through what their disclosures were, because there are so many lists.
Oh boy.
My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at.
Oh, now she's mad. Now she's like, but Your Honor, no, Your Honor, that's not what we want. Your Honor, that's not what we want. EDB, you've also misinterpreted what we're asking for. I did. Your Honor, that's not what we want. What we want is not for you to tell them to add more information. What we want is for you to tell them they can't have the witness. That's not going to happen. The court said your work's not done. And she goes, but Your Honor, I don't want them to do it. I want you to limit it. No, Your Honor, don't. No. I want you to cut their witnesses off at the knees. That's not going to happen in January. That's not going to happen. It's just not. They've been warned. If they don't fix it, it can happen.
Listening to the court's comments
the court's not gonna
understanding
do
where
that.
we were a moment ago when we spoke, I feel like I must go through what their disclosures were, because there are so many lists. My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at quite a disadvantage, not knowing what their experts would
Well,
say.
and if they supplement, you certainly can supplement based upon what they supplement, and I will permit that. And that's kind of the nature of the beast.
He just treated
I
it as
do
a jumping
appreciate
off
that.
point.
And should that become necessary, we'll definitely take you up on that, Your Honor. I want to make a record about some of their expert disclosures, though.
She's like, I'm not done yet.
All of the
He's
lab
done.
people, they have lab reports and notes. The Idaho State Police Forensics Lab, I better be really clear on that. Other than the wiggle room language, which would ask that they not be permitted to have any wiggle room language, the lab reports are fine, with the exception of one of the witnesses, Miss Nowlin, that they've disclosed, and she's written no reports.
Is that the one they said is a rebuttal witness?
They said she might be a rebuttal witness, so I suppose now they know what our witness is going to say. The I want to talk about the cast report. The court's heard a lot about the cast report.
And her saying, well, now they know what our witnesses are going to say. Yeah, they have to. They have to know what your experts are going to say. There is no hiding the ball. Everything gets disclosed. It is not gamesmanship. Civil law, different altogether. This is, you know, when Anna's saying, well, now they know what we're going to say. Yes, they have to. And then they're going to supplement, and then you're going to supplement. There is nothing abnormal happening here. There's frustration.
When I say cast report, that's because that's what it's called. It's really a PowerPoint presentation. There's not any analysis in that. There's just, this will be my testimony. This is what it's going to be. Without much more, it's a picture, and it has some dots and some arrows. Your Honor, that needs to be cleaned up. We need to understand the analysis that went into coming up with those PowerPoint presentations. That's just not plain good enough. I would let the court know that the cell phone experts, there's wiggle language in both of those if the court hasn't seen that. Their disclosure number, that's Mr. Cox, that's a person that has not written a report at all. We have no idea besides the state's disclosure what that person is going to talk about. Agent Douglas that I talked about before, I don't think I need to make further record. There's a lot of documents, no analysis, no opinion stated. We put several of these in our pleadings, and so I won't go through all of them. I'm highlighting the ones that we're really concerned about. We have 3 that looked at digital data. The court should understand there's 60 some devices. There's digital data from third-party sources, and there are 3 people that are listed with just lists of things. It's Mowery, Tanzola, and Urig. They have lists of devices or social media accounts that they're going to talk about.
60 devices?
That our expert told us would take 3 years to look at every bit of the data. So having no clue what's going to happen, I can envision exactly what the court's fear is when we get to jury trial, me wondering if this particular thing was ever disclosed. So I definitely needed to make a record of that.
$60 devices is a lot of devices.
Further with the lab personnel, there's a caveat that says they'll talk about other people's reports at other things that are outside of their report, in addition to some of the other wiggle language that I referred to. Your Honor, given that the state is now cautioned to think about those things and submit more, I feel like it's important for us to bring out that we have a right to confront the evidence that's brought against us. Bryan has constitutional rights, United States and state of Idaho constitutional rights for a fair trial and to confront evidence. The expert disclosures are designed to advise us of what the state is going to do. Their disclosures were insufficient. I appreciate what the court said, but exactly what the court's worried about will happen if we don't have better disclosures. The jury will be in and out while we make sure that we have a clean record. We appreciate what the court said today, and would ask the court to order the state to comply or for the court to exclude anything that hasn't been disclosed so far. That's it.
He made clear he will.
So I'm going to give like both sides an example of what I expect, so that you understand. There's
My
been
rules.
talk in this case about DNA. If somebody's going to talk about DNA and your intent is they're going to let the jury understand what DNA is, and essentially going to do a mini course on DNA, I expect to see that in expert disclosures. Not that they're going to do a mini course on the DNA. I expect to see the mini course in the disclosures, if that makes sense, in terms of what their opinions are, what their information is that they're conveying that is expert. In
The
nature.
state's like,
And so it really
That's a
does
lot.
behoove both sides to spend the time.
not every
to
judge
do
asks
that.
for that much.
And that's the last I'll say about that.
That's the court's like, no, you're
It
going
is
to
probably
spell it all
the
out.
most critical thing that you have to do at this point, prior to trial is to ensure that you have not just disclosed, but potentially over-disclosed those opinions and what is required by the rule. All right, is there anything else with respect to those?
Your Honor, is the court giving the state a new date to fix their disclosures?
I'm not giving either side a new date. You understand, I think, what I expect. So you can choose to try to supplement those. If they are simply expansions of what it is that they've disclosed that are just being more fulsome, I'm probably not going to have a problem with that, given where we're at in advance of trial. And then defense certainly can look at those and decide that they want to expand or change or whatever their opinions are based on that. If it's whole new stuff, then you're going to have to demonstrate to me, new opinions, new lines, or even new experts. You're going to have to demonstrate why you didn't get that in the timeline.
Thank you.
Thanks, Your Honor.
Okay, is there anything else that we need to take up today?
Nothing from the defense.
State?
I don't know whether we're going to have a Frank's hearing or not. I need to go and do that. But if you don't mind emailing some dates that you have available in the next, say, 3 weeks to do that in the event that we need to do it, I would appreciate that. Okay?
Okay.
All right. Well, I appreciate everybody's work.
That's enough work for
not
this
just
day.
For the hearings this week, but in this case in general. And I know how busy you all are, and I hopefully have not taken more of your time than is necessary. Travel safe. Thank you.
All rise, please.
And we're out. That is the end of day 2 of the hearings in Idaho. Well, the judge just had some strong words for the parties. Let's try to give a summary of where we're at and then go from there, because we need a lip gloss. Then we'll do a summary. Then we'll do some questions, and then in about 3 hours today, we might be done on this Friday, which is nice. We've streamed a lot this week, and I have a lot to catch up on before we get to quick bits for next week. And this was busy. So let's try to summarize what happened over the last 2 days. So over the last 2 days, January 23rd and January 24th, there have been hearings in Idaho that some were sealed, some were public. The defense is arguing all of their motions to suppress and a motion asking for a Frank's hearing, as well as requests for discovery. With regard to the sealed portion of the hearing, that was regarding investigative or IgG DNA, that was largely sealed, but the arguments were public, and that's where we picked up on January 23rd, Thursday. Then getting into Friday, we got into the rest of the motions for suppression. The defense is asking essentially to suppress all of the evidence that came from 14 different search warrants, arguing largely that either the search warrants were overbroad and not particularized enough, or that the search warrants were so deeply based on that investigative or IgG DNA that when that IgG DNA gets thrown out, that the rest of the search warrants should get thrown out. And then, of course, the argument that there needs to be a separate hearing with evidence regarding the search warrant affidavits, that Frank's hearing. The court has indicated that they do not know if that hearing will be granted, and that they will be issuing orders forthwith, which means really as soon as practicable for the court on all of these motions. Remember, it was over 14 motions. So the court is probably going to lump together most of the motions to suppress, then the Frank's motion, the IgG motion separately. And then on the discovery motion, the defense was asking about the state expert disclosures, saying that the state had not fully disclosed enough the opinions of their experts, the reports of their experts, and what additional information there will be. And the court strongly warned the state that the expert disclosure work was not done, and those expert disclosures needed to be supplemented so that the opinions of the experts were more fulsomely laid out in the expert disclosure. And the court made clear that what they expect is a substantial amount of information in the disclosure, not just bullet points. If it is a witness who is a crime scene tech that's explaining what DNA is, the court expects that that witness disclose how they will be explaining what DNA is. And that is the example that the court gave. This case still has a lot of litigation to go before it starts trial in October. The court warned the parties that he did not want to be stopping and sending the jury in and out so that they would have to find where these disclosures are. We know that just in these motions hearings, the defense submitted over 1,000 pages of supplemental material to the court. We know from arguments today that there are over 60 devices in this case, and that is not just devices from the defendant, but these are all kinds of devices. That could include things from the defendant's apartment, personal devices to witnesses, to victims, to others. This could also include security cameras and things like that. So over 60 devices in this case that will need to be looked at. And the defense said their expert indicated it would take over 3 years to look at all the data from just those devices. And we know there's more data than that in this case. There's over 50 terabytes of data. Oh, chat, thank you. Chat is Bay. Trial starts in August. Did I say October? The words sound too close, clearly. Trial starting in October and running. No, I did it again. Oops. Trial starting in August and running through at least November of 2025. So there is lots more to come. This judge has been thoughtful in their rulings. I'm interested to see how they break it down. Some of the defense arguments are for now. Some of the defense arguments are preserving this case for appeal. Do I expect this level of motion work in a case this serious? Absolutely. And we've seen that from the defense. These attorneys are incredibly swamped with the amount of work they have to do to get this case ready for trial. And it seems that all sides are A, doing that, and B, also tired. So it's going to be a very busy and long road to get to that trial in August, but also for the attorneys between now and then, there's just not going to be enough time to do everything that needs to get done because there is so much volume here. And for the prosecution, it seems that one of the problems is going to be that so many chefs were in the kitchen in this investigation. Trying to parse out who did what part of what looks like it is going to be at least somewhat difficult to parse in a way that is in order. Oftentimes we will see one or two officers come in and they know everything that happened in an investigation. Here, there are multiple officers in charge of different parts of this investigation from multiple different agencies, and that can make it a little clunkier when it gets to trial. But this is going to be a long trial. What I do trust from Judge H is that this trial will move as smoothly as humanly possible based on the work that he has also put in leading up to this case. So it's nice to see the attorneys working together better than we've seen in the past. We have not seen any of the courtroom devolving into the more salacious language that we have seen in the past. We have not seen the attorneys making accusations to one another. We have not seen Prosecutor Santa lose his cool again after being feisty with an expert about whether or not he held a press conference. We've seen these attorneys really settle down into this case with a judge who is not here for that level of hyperbole. I'm waiting for this judge at some point to say that level of hyperbole is not helpful. Look, those of us that love the drama, and occasionally who doesn't love the drama, in a criminal case this serious, we're not really going to see that level of courtroom theatrics. I appreciate that the judge has really toned that down. And I think when this goes to trial, we will see that continue. because of this judge's no nonsense demeanor. He really did take charge of this trial and say, all right, children, what we're going to do is get this trial done. What we're not going to do is sit here and just fight back and forth with each other and yell back and forth at one another and huff and puff. Though we see a lot of that in civil, this judge is not having that in this criminal case. And I think in the cases that I'm covering, we're going to see some civil judges get real feisty real quick in some of the cases. So with that, we need to get to your questions. You've got questions. I've got questions. We've got questions. And then it's time to go get some lunch because I've been sitting in this chair streaming for way too long this week. I love being with y'all, but it's also been a long week and I need to just get up and get other stuff done around the house, including laundry. It's good to see all of you in the chat, Lawnards. You guys are the best. Yes, this judge does not play. To everyone who gifted memberships during the stream, welcome new members and thank you for your generosity into this community. Colleen, thank you. Jessica, thank you. Just because, thank you. I really appreciate it. This is such a great community and I know many of you rely on gifted memberships and really enjoy that. I think it's a great feature of our community, supporting our community, and I love it. CeeLo, thank you so much. Bone Arrow, thank you so much. You guys are absolutely the best. Curious Liz said, as my name is Elizabeth, I'll pay to have him say that, or any sort of spicy phrases. The Law Nerd Book Club is full and well, becoming less and less theoretical, but the get in the car, Elizabeth, is going to happen. Casey Cat said, EDB, if Corporal Payne gets promoted, will he become Major Payne? One can only hope. One can only hope that Mr. Payne gets a promotion in that way, but I don't know what they do in Idaho based on how their rankings work, because it can be different based on the different jurisdictions. But I want it to happen too. Kadora, good to see you. Greetings, Law Nerds, from your friendly neighborhood court reporter student. 6 months left in EDB's commentary is now just additional colloquy when I use lives as speed building practice. Cursey words not redacted. We don't redact the cursey words in court. You wouldn't. So it's perfect. And if you ever want, well, there's lots of places to get all the stuff on YouTube without me speeding it up and speeding it down. But hopefully my pace on stream is slightly faster than my court pace, but not that much. But occasionally the court reporters would be like, Emily, please slow down. Just slow it down. So my court pace was a little bit slower. My stream pace is a little bit faster. Sean said, so what I'm hearing is that Amazon is not a good place for the Book Talk girlies to order their biker gear, duct tape, rope, and chloroform for Valentine's Day. Sarcasm. I will plead the fifth on that one. I'm just saying Amazon keeps a log of everything that you do. So I don't know. If you pay cash at Tractor Supply, are you as easily tracked? I'm just saying. Sapples, thank you for stopping by and saying hi. I appreciate you guys too. Louise said my 43rd birthday is tomorrow. Best wishes to the other Aquarians celebrating this month and next. I'm sitting here in my comfy EDB hoodie with my gavel. Yes, my youngest is an Aquarius. His birthday is coming up early February. Carrie said, EDB, when is the Kohberger trial currently set for? August. How likely is it that the trial will actually start then? I think pretty likely on this one. Something substantial would have to happen to shift Judge H in shifting this trial significantly. Could I see wiggle room on a couple of days? Maybe, but Judge H pushed it back from where they asked for. He asked all the parties. He said, I want to set a date and I don't want to move that date. So let's all, let's get serious. about what that date's going to be. And he was not, I don't think he'll be persuaded. Not to mention, it takes substantial resources for any county to do a trial that takes that long, to take up the courtroom for that long, to shift their calendar, not set calendar. Like, it's a logistically quite a lot of work. So it's going to be a lot. I saw a couple questions about when I will be covering Lively Baldoni. Again, I have a list of about 100 things I need to cover next week. I don't know when we're going to get to all of them, but there are so many things going on. So we will be covering some of it very briefly in quick bits that'll drop on Monday. Members, you will get notification to do the BTS with me for quick bits. I don't know yet if that's going to be today or tomorrow. I need to look at how many of the things I want to talk about are prepped, because I forget all of what I did last night because it got late and my brain is just like, we're tired, we don't remember. But we will be doing that. So there will be an overview of a lot of what's going on Monday in quick bits, including new filings in the Karen Reed case, new Diddy case, the lawyers getting all up in each other's business in the Blake Lively, Justin Baldoni's case. Lively's lawyers brought the audacity. So we're going to talk about that, because the members who saw it on the members only live, I was going through it. I was like, oh shit. Did you really think that was going to work for you? No, it's not going to go well. That's not going to go well at all. And there's been more filings. I'm sure there's more filings today. There were more filings yesterday. So I'll try to summarize those, because I really do want to go over Corey Richins and see if we can get the entirety of the hearing. I know parts of the hearing are up. I want to see if we can get the entirety of the hearing and go through the Corey Richins hearing, because it's going to be incredibly interesting. So I would love to have that. And without being in Utah to plug into the truck, Court TV is like, yeah, if you're in person, you can plug in. I'm like, can you please just post the whole thing? And we have parts of it up, but I haven't seen the entirety. So I would really love to go over, even if we need to do it in 2 streams, I would love to go over the Corey Richins hearing next week. So I'm going to try to summarize documents so we can get into the cases, into the court hearings that are interesting, because Bloodworth is interesting. They played some audio of Corey Richins when they went to get her phone. There's a lot there. And then I know you guys want me to go over the Karen Reed motion. We've got Sarah Boone responses. It's a lot. It's a lot. So when will we get to it? We're going to get to it next week. I just don't know exactly when. I will try to prioritize Karen Reed, because I know you guys are asking for it quite a lot, and we'll break it down. I will also summarize it in quick bits. So Casey Cat, thank you so much. I appreciate it. My mom moves to ask EDB about her middle name. Well, you can't forget the D. Today, the EDB stands for danger. No, the D in my name has become a joke at this point, but it is just my middle initial. And when I got married, the amount of Emily Bakers that there are in the world was quite a lot. So I started using my middle initial more, just to differentiate. And even at the DA's office, there were other Emilys. And so there would be times the courts were like, wait, which Emily is on calendar today? Is it you? Is it other Emily? Which Emily is it? And that was much. So yes, then we started using the middle initial. Today, it has stood for dongle. Today, danger. It just depends on the day. Maybe dragon. I think maybe dragon more than danger at the moment. We'll go with that. We're gonna go with that for the foreseeable future, or at least until I finish reading Onyx Storm. Is Emily Dragon Baker is where we're at. So I saw a few other questions. Megan said, "Did I watch Traitors last night?" Yes, that is one of the things I took time for last night and got to bed way too late. And why Mom D is for distracted, that is also very accurate. That is very accurate. It's not just an initial. I joke about it. It is an initial, but it's an initial that stands for my maiden name. So, yes. So, Sue said, please wish me a happy 50th birthday for tomorrow. Sue, happy 50th birthday for tomorrow. So it is, yes. So that's what it is. What was I going to say? Traitors is amazing. I love it. Do not, me speaking into the universe about a show that is already finished being filming. Do not come for my Dolores. Emily, Dolores Catania Stan Baker is where I do not come for Dolores. I will lose my fucking mind. So do I love Traitors? Yes. I think it is a great like competition reality show. It's really fun. Even if reality is not necessarily your thing, it's more like a game of Among Us with a twist. And I enjoy watching how people play that out with the like trying to sort who the traitors are and kick them out and trying to vote out. It really is like Among Us, trying to vote out the traitor and not accidentally vote out someone who's not a traitor. And then the traitors get to yeet people and then they get to strategize who they get rid of to not disclose who they are. And it is the strategy game of reading people. How will people react to something? And then the chaos. I don't know how the editors do it because they have to have so much footage of all of this. And then to tell us the story in a way that makes sense and so that we can see twists or not see twists. But also Elizabeth Perry said my husband plays poker with Boston Rob all the time. How does anyone play poker with Boston Rob? Boston Rob is the fucking king of reality games. The man is just like, I got all these people running all over the place and they have no idea what's happening, but I do. Like Boston Rob is a reality competition show assassin, and it is just fucking amazing. I love it. I love watching Boston Rob in this environment. It's so fucking good. It's just so good. I love it. I love it. Love Boston Rob. Love Dolores. Love seeing people snark at Tom Sandoval. Not gonna lie. There's a little schadenfreude there. The outfits are a choice, but isn't that what we love about reality TV? Like the fashion of traitors is also such a serve. I'm so upset Chanel Ayan's not on that show any longer. She is fucking hilarious. We'll talk about this on a members about the amazing interactions I had with Chanel Ayan at BravoCon. She's so funny. Traitors is on Peacock. She's so funny and unfiltered. And I love that Peacock is pretty unfiltered, but she's so funny. Just love. However, if you don't yet have Peacock, here is my my thoughts on that. I know they always run some kind of a free trial. I would wait till this season is done. And when this season is done, I would do your free trial of Peacock and just watch through all of the seasons once they are finished. So wait until it's done. I'll tell you when it's done. So if you don't know who any of these people are, it takes all of the different types of reality shows and puts everybody into a house to play like a murder mystery game for a limited period of time. It is hosted by Alan Cummings, who is fabulous. It's so good. I can't rave about it enough. And it's also fun to see people from Real Housewives and Vanderpump Rules and like the Bravo world, plus the Survivor world, plus like the Challenge world, plus like the Bachelor and Bachelorette world. It's interesting bringing people together from all these different aspects of reality TV and having them interact with each other. Love it. Love it. Love it. 10 out of 10. 10 out of 10 for the way that reality competition happens. I'm not surprised it won Emmys. It is so much fun. It is so much fun. And it is really a fun and different take on reality TV. And it's fun to see people in a different light. Bob the drag queen was on this season. Bob from The Biggest Loser is on this season. It really is fun. And Traitors UK is completely different. Yep. And I am waiting for Traitors like Internet Personality Edition. at some point they're going to have to start weaving in internet personalities to the others, because I think there's a whole room for a different dynamic with those on TV versus others. Megan said, I cried at Bob H's heart attack story. Oh, same. As Bob H was talking about how challenged he felt recovering from a heart attack and then in some of those physical challenges, it resonated incredibly deeply with me. After anyone who has been injured and been like, I could do this before, I can't do this now. It's like, I felt it like in my soul. I felt everything he was talking about. And so many of us have been there. And then Bob the drag queen just fucking served. Love it. I could rant forever. Ophelia Wild, thank you for the very kind super chat. That's very sweet. And this is a very kind sentiment. I think I speak for chat when I say that you help us live our lawyer dreams. Have some coffees or matchas on me. Thank you. Also, hi to G. Also, no more wiggle words is my weekly meme. I mean, the wiggle words were pretty fantastic. No more wiggle words. Heather, I didn't know that. Heather said, can we give props to Alan's stylist, Sam Spector? Follow him on IG. I'm going to follow him on IG too, because apparently if I follow him on IG, then it means that we are destined to become besties. And I didn't know that IG had that power, and I'm waiting for it to happen because I have been following Alona Mar on Instagram for quite a while, and we are not besties yet. And if IG has the power to make that happen, then I'm here for it, because God, I love her too. If you guys have not been following Alona Mar's journey with her broken nose, because rugby player, it's very interesting to see Alona Mar's broken nose day 1, day 2, day 3, day 4. Anyone who, is following along what a broken nose looks like or might be interested. She has been hilarious in the, don't we love my broken nose? God, I love her. She is just freaking goals. I'm going to go look for Alan's stylist, Sam Spector. Heather, thank you for calling that out. That's fantastic. Because damn, Alan's looks are just fucking gorgeous. Gorgeous. All right, chat. It is time for me to say goodbye. We have been talking quite a lot this week, and it is very, very dry, and my voice is killing me. I will be back on Monday with Quick Bits. Get the Law Nerd app. You'll know where to be. Monday, Quick Bits. Tuesday, Wednesday, Thursday, stream. I will see you, members. We will do our BTS. I don't know when yet, but we will do our BTS. I'm going to take a little bit of a voice break. You guys have a good rest of your week. Happy Friday. Mods, Team Baker, thank you for such a long week. It is really not my goal to do 7-hour streams. We went to streaming 3 days a week to do shorter one-topic streams so that they would be easier to rewatch. And then these lawsuits are so fucking long that there's no way around it. There's just, and then we're streaming for 7 hours going, I said I wasn't going to stream for 8. It's like a full fucking work day. All of you were like, started work, Emily's streaming, end work, Emily's streaming. I'm like, yes, I've talked an entire damn work day, but I love it because I love being with y'all. So have a great weekend. Take care of yourselves. Stay warm. Stay warm. Look, y'all, Florida, Louisiana, I know you got snow. Don't get wild. Cars slide. Like, just be safe. Enjoy. Y'all are wild on the internet with the Houston with the snow. Just all of you be safe. Ireland also. We know you guys were getting some wild weather too. So you guys take care of each other. This community just continues to remind me about the best parts of when we get to come together and talk about all of the different things going on in the world. And I love that so much. So thank you all for participating in it with me. And I will see you. I'll see you on Monday. See you around the internet. I don't think I've been on social all week. I've just been streaming all week. So with all of that, I will see you soon. Thank you for being here. Thank you for being a Law Nerd. Take care of yourselves. Big hugs from me. Have a good weekend. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. because you never know when something's going to pop off. Thanks for being here, and thanks for being a law nerd.